won't, sir. We have a street named after you, though.
You go to what?
You get a street named after you.
So, during World War III,
2, you mean?
World War III,
3.
during World War III, the military is going to take all the Royal Caribbean ships, turn them into hospital ships.
We did that. Not hospital, but when I don't know if it was the tsunami in Japan. There was some world event that we turned the ship into a floating hotel for. I forgot which natural catastrophe it was, but we've done that before. Yeah, Fujiana. Yep. I think it was that. I forgot what else it was, but we have done that in the past. Just because it's 3,000 rooms, it's perfect for a hotel.
Could be better. How's the stock going?
Well, with this whole Iran thing, it went down, but still.
Down the other day, yeah.
Yeah, it's trading at 263, I think, today. It's gone up since then. Not a lot, a couple points. But once this thing with Iran clears up, it'll go back up. I think it'll be steady around 280, 290. Oh, yeah. Yes, sir. Stock options, and I get a discount every quarter. Oh, no.
You want to push public?
Yeah, but yeah.
You want to push? You can push everything and just bring item 5 up to the.
No, just do the road.
Huh?
Just do everything, do the proclamations, read everything, do the consent agenda, and then go straight to 8 and 9.
Call to order Minneola City Council. If we'll all rise for a moment of silence, and Vice Mayor, if you'll lead us in the pledge, please.
United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you.
Agenda review. Vice Mayor,
Looks good.
Ms. Flynn,
That's fine.
Mr. Hernandez.
Looks good.
Okay. Scott, we good?
We need to table, as it's referenced on the agenda, table items 13, 14, and 15 until the next meeting on May 19th.
Okay.
Those are all with regards to the Citrus Ridge Commercial PUD.
Project updates, you want to go through those? Joe, you want to move those to the end of the meeting?
Yeah, but let's do
Public
what that
comments.
first. Make a motion to tables item 13, 14, 15 on May 19th.
Okay, you've got a motion, get a second?
I'll second.
A first and a second? All in favor, say aye.
Aye.
All opposed?
Thank you.
And then, yes, we will suspend project updates. Mark, I think there was just one item. Not sure if you're going to bring it up in your reports, but I believe it was for the groundbreaking for that park.
Yes, I'll bring it up in my report.
Okay, great, thank you. Okay, other than that, any other major items, Mark, to report on any of the projects from a high level? Not right now? All right, yep, we're good then.
Okay. Proclamation,
Do you want to do public comments first?
public comment. Anybody that always want to speak on something that's not here? Okay, bring it back, dude. Oh, sorry. My bad. You blended in with the chair, my bad.
Jennifer Morse, 1064 Golden Dawn Loop. Just a quick question on that big warehouse building. What is the landscape buffering that you guys set up with them? Like, are we gonna see some trees planted so we don't have that eyesore? Some beautiful palm trees? Do we have a wall coming?
I can have planning get with her tomorrow and show her the plans.
Yeah, I think it's all stipulated in the PUD. I think we were all just a little busy, obviously, with what's behind you, but
Yeah, I hear you.
yeah, if you could talk to Mark tomorrow, if not, just call me directly and I can go over the PUD with you. We could review it.
Okay, thank you. That's it.
Okay. Anyone else? Okay. You are project update, you want to skip it and come back?
Yeah, we're skipping, yeah.
Okay, proclamation, mental health awareness.
Mental Health Awareness Month, May of 2026. Whereas mental health is essential to everyone's overall health and well-being, and whereas all people in the city of Minneola experience times of difficulty and stress in their lives and should feel comfortable seeking support without fear and judgment. And whereas mental health conditions are real and important in our community, yet silence and stigma often prevent individuals from reaching out for life-saving care. And whereas the theme of 2026 focuses on turning silence into connection, emphasizing that no one should have to navigate their mental health journey alone. And whereas the early effective treatment and community support, individuals with mental health conditions can recover and lead full, productive lives. And whereas each business, school, government agency, healthcare provider, and citizen has a responsibility to promote mental wellness and support those who are struggling.
So I, Pat Kelly, set my hand upon the cause of the Great Seal of Minneola on May 5th. And the service?
And I have here National Day of Prayer, May 7th, 2026. Whereas prayer has been a foundational part of our nation's history, providing a source of strength, guidance, and unity for its people since its earliest days. And whereas the first Congress issued a proclamation for a day of prayer in 1775, and in 1952, the United States Congress passed a joint resolution establishing an annual National Day of Prayer. And whereas in 1988, Public Law 100-307 was signed, designating the first Thursday in May as National Day of Prayer, inviting people of all faiths to pray for our nation. And whereas on this day, citizens across the city of Minneola are encouraged to gather in homes, places of worship, and public spaces to offer prayers for our leaders, our first responders, our military, and the peace and prosperity of our community. Therefore,
I, Pat Kelly, do hereby put my hand on cause this Great Seal of Minneola on May 5th, 2026. I'm going to take a moment, just because we're doing the proclamations, for just to say something briefly. For those who don't know, this will be my last meeting full meeting as the mayor of Minneola. I will be stepping aside. With that said, I don't have an official proclamation, but I do have a letter that I would like to read. If you'll indulge me, please. Councilman Eric Hernandez. As a step away, I did have some initial hesitation about what Minneola's future would be like under the next generation of leadership. Those concerns have been fully put to rest by watching you in action, particularly through your leadership. You've demonstrated a clear vision through projects such as Trailhead Park upgrades now underway. More importantly, now serving as a strong and effective point of contact and standing firm against the big box project developments proposed for Minneola by working diligently and professionally with the developer and ultimately helping to bring the withdrawal of their plans. Your passion, leadership, vision, and financial stewardship speak clearly to your commitment to the city. I'm confident that Minneola will exceed any vision I ever had, knowing someone like you will continue to remain vigilant and dedicated to what's best for Minneola and its residents. I would like to thank you personally, Mr. Hernandez.
Thank you. Thank you very much. Just one quick note. Thank you, Mayor. Appreciate that. I do want to thank everyone who was involved with this project, specifically as well P&Z. They did required their input, and they have a lot of good input regarding this project as well. So thank you, P&Z members, as well, for all your due diligence and all your hard work.
Okay, thank you. Okay, moving on. Manager's consent agenda. Can I get a motion for approval?
I would like to ask if there's any chance that we could pull item 7, the pier construction, out of the mayor's consent agenda, since we'll be voting on it separately in the Minneola Community Redevelopment meeting following this meeting.
I think it has to be approved by both, does it not, Scott? Or how does this work?
Typically, no, we allow, any council member can pull out a single item and just vote on it separately. That just means it
Oh,
wouldn't,
so you want to
Just-
vote on it separately?
just vote on
not
it
pull
separately,
from the-
right.
Okay, that's fine.
Which item was this?
She wants to pull 7. And then vote on it. And that's fine. Sorry, I
Oh,
misunderstood.
that's okay.
You want to shift item 7 to below item 12?
Okay. So we're going to move, can I get a motion to move item 7 to 12?
So moved.
Okay. Can I get a second?
Second.
First and second, all in favor say aye.
Aye.
All opposed?
Nay.
Okay. 4-1, it goes. Okay, with that said, can I get a motion on the rest of these, item 1 through 6, please?
So moved.
Second,
I'll second.
all in favor say aye.
Aye.
All opposed? Motion carries. Discussion item. Scott?
yes, we can go ahead. Items 8 and 9 both deal with the same item. In your discretion, we can, like we've done before with comp plan items, we can handle them together, discuss them at the same time, but we'll need to vote separately at them at the end of the item. With that, Resolution 2025-17, a resolution of the City Council of the City of Minneola, Florida, granting a special exception use permit pursuant to Chapter 102, Division 12, Section 102-343 of the Land Development Code of the City of Minneola, Florida, for property generally located east of North Hancock Road and north of County Road 561A, Minneola, Florida, allowing for the development of a convenience store with fuel operations, providing for conditions, providing for recordation, providing for an effective date. Just a little bit about the process this evening. This is a quasi-judicial matter, so by chance, if there's anyone here tonight that may wish to speak on this item, if you'd like to please raise your right hand now and repeat after me, or you don't have to repeat after me, but do you swear or affirm that any testimony you give this evening is the truth, the whole truth, and nothing but the truth? If so, please say, I do. I do, thank you. When the time comes from public input during the meeting, there's a sign-up sheet here. I think there's also one's in the back. If you could sign one of those sheets, and if you're queuing up in line, if there happens to be a line, you can certainly sign at that time, so you don't have to sign when you come to the podium. When you come to the podium, though, please introduce yourself and, if appropriate, your address, particularly if you're a resident.
I just want to clarify, there is a court reporter here this evening that was brought not by the applicant. If I'm correct, it wasn't by the applicant. So just to let you know that there is a court reporter here, so we don't get I didn't know.
That is their right. Just as far as agenda, if you will, like we normally do with land use things, I'll go forward and give a little introduction as a sign of the apocalypse. I'm supposed to walk through a PowerPoint, which isn't something I usually do, but I'll struggle my best. I can read, so if somebody can help, oh, good, thanks. Christine will give me the clicker. So I'll give that as by way of an introduction. After that, the applicant is here this evening. I think they also have a PowerPoint presentation as well, and can speak particularly on some of the new items that have come up since this last came before the assembly. After that is when it would be opened up for public input at that time. Everybody would have a chance to speak. If you testify previously on this, for instance, when this came before in November, it is not that this is a carryover, if you will. That testimony will be preserved. However, you won't be punished if you wish to repeat that, but in case, in the interest of time, if you don't feel the need to repeat yourself again, that would be appreciated.
Scott, question, when it comes to item number 8, which is the
Yes.
mediated, to consider a request to approve the mediated settlement, is that something we need to discuss now, or do you want us to discuss that after your PowerPoint?
We can do that. Here's the thought. I think we can just do both of those at the end, vote at the end after we take all the discussion. The public's allowed input on it anyway, and I think they probably wish to talk about the subject matter, so I just figured we'll just talk about it all and then vote on them separately at the end. But you're right. What Mayor Hernandez is talking about is
Councilman Hernandez.
I'm sorry, Councilor Hernandez. Gosh, that is a slip. The
That's on the record, though, Scott.
I know, that is on there. Sorry, Mayor, we're not getting rid of you. As I turn red, like the shirts. The mediated settlement agreement is something that, and we'll talk about that as part of my introduction. That's something that we'll vote on first before we actually get to the resolution. I would recommend that they would approve the mediated settlement agreement. All that, frankly, will mean is that it'll be presented, the resolution can be considered for a vote this evening, so it doesn't bind that to anything. The resolution is the real deal, what you're all basically here for. And then, of course, at any time, if council has any questions, both of the applicant or any of the folks, that typically they would keep those comments till the end, but they'll then have a chance for whatever deliberation they need at that time, and of course, any statements that they have. Yes, question? Yes, sir.
Does one person get a chance to address both issues and take their 2 minutes for items 8 and 3 minutes for item 9?
That wasn't anticipated. I think the mayor has always been.
I'm not the time police.
He's always been, I was going to say, he's always been gracious about time.
Out of respect, there are a lot of people here. I just ask you to be respectful with your time and try to not be repetitive. Some of it will be, because everybody's going to say, we don't want it. We got that. But some of it, we're all adults here. We're good. We'll respect it. That's fine.
Perfect. Thank you. Thank
Scott,
you.
so I'll ask, it's after we do this presentation, if the dais up here can have a few minutes to discuss, because I do have some questions and comments regarding the agreement that was presented to us prior to going to public
Yes.
comment. Great, thank you.
That'd be fine.
So I just want to clarify, so you want presentation,
Comments from us,
comments,
and then we can go.
audience?
Yes, correct.
Okay, are we all good with that? I just want to make sure I'm fine with that.
Yep.
Okay. Perfect. All right, with that, I will try to walk us through, this is basically background information. The first slide you have up there is the location of the project. As it shows on here, and I think all of you are aware of this, it's at the northeast corner of 561A in North Hancock, and it's southeast of the Del Webb community. North Hancock is under construction and will connect to the County Road 455. That is an incredibly old picture, as some of you are nodding. That area has changed dramatically, and in fact, I think it has connected all the way to 455 as of this point. Huh. Just like the TV. Interesting, I got it. The second thing, this just goes a little bit down to it. There have been some comments. This shows that it's within the Hills of Minneola PUD. You'll notice immediately to the right is planned to be currently a self-storage facility. Del Webb, as many of you are familiar, is that large dirt area to the northwest. Of course, that is remarkably different now. And it is, as it notes on there, in close proximity to the Minneola Ridge PUD. You'll notice the future townhomes to the left and some future single-family homes to the other side as well. One thing, and there were several comments about this, that it is worth noting, this is part of the Minneola Hills PUD. As is noted on there in red, that's the site. This project is designated as a commercial parcel. There were many people that said they were against the rezoning. This property does not require rezoning. It is commercially zoned, which permits a variety of B1 or commercial uses. The subject tonight is, though, to have the gas pumps at the location, rather than just a convenience store, which is permitted, requires a special exception. We'll get to that in just a second. By way of background and just a time frame on this, but you'll remember many of you were here back in November of 2025 where the City Council first considered this. At that time, they denied unanimously, I believe, the special exception. As is their right, the applicant soon thereafter filed an application under Chapter 7051, request for relief. This is a specific statute that deals with land use decisions that allows, short of filing a lawsuit, an applicant who has not pleased by the outcome can basically file an appeal. That process involves what happened here. A magistrate is appointed. A magistrate is typically, and in this case, was an experienced land use attorney who is charged to basically listen to the case and eventually, if necessary, make an opinion somewhat like a judge as to what they feel the correct outcome could be. In this case, the first step, though, is before they get to a hearing and make an opinion, there is a mediation proceeding. Essentially, the thought is they're trying to see, is there any outcome or additional conditions that could be added that could possibly address the concerns that came up in this case at the November hearing, and with those conditions, is it something that could please both the applicant and the city? At that, we had two separate mediation dates in February and March of this year. The result of that was a mediated settlement agreement, which is the first item for consideration. What the mediated settlement agreement essentially says is that the applicant has agreed to amend to add additional conditions, and we'll go through those in a second, that they will, on top of everything that was previously offered, that they will agree to do in return for being allowed to have a convenience store with fuel operations at that location. The council is not bound by that. Even if they approve the settlement agreement, all it means is that they will consider the conditions at a public hearing, which is frankly what they're doing here this evening. If they vote yes at the end of the night, then it's been resolved. If they vote no at the end of the night and turn it down, it will then just go back. The mediation agreement is null and void, and it goes back to the special magistrate for further proceedings. There'll be a hearing and more to come after that. And perhaps I should elaborate on that, what those further...
Can you elaborate on more to come?
Yeah.
You kind of left them hanging there.
Yeah, I was going to say, I kind of did. The further proceedings, what happens is if it's voted down tonight, it will go back to the special magistrate, who will then hold a hearing where they will take evidence from the applicant, and a few additional folks have filed to be a participant in the proceeding. Mr. Pownell is one of those folks who actually was at the mediation and will be allowed to present evidence at the hearing. Once the magistrate hears all of the evidence, like a judge, the magistrate will then issue a recommendation to council that will be brought back, kind of like this mediation agreement is to council, whether it's yes, it should be allowed, no, it should not be allowed, or yes, it should be allowed with some other conditions, whatever that happens to be. Again, though, because the magistrate is not a judge, they can't force the council to do anything, essentially, except consider it. The council will then have to consider it. Everybody would be notified when that would occur if we get to that point. And then council, again, would make a consideration after having the benefit of all of the findings of the magistrate at that time, and then can take further action at that time again. So now we're dealing on the mediated agreement now to try that, and hopefully one way or another we can get it resolved. Yes, sir.
I just want to clarify, it's the same magistrate the first round?
Yes.
That will be the second round?
Same
It's not like you changed?
Yes, same magistrate throughout the entire, so the same magistrate that was orchestrating the mediation will be the same magistrate that will eventually be issuing an opinion.
Is that a Lake County magistrate, or is that do you go to different counties, or is that?
No, our magistrate is a former Osceola County attorney who now practices land use law in Orlando.
Okay, thank you.
So, okay. Okay, moving on. I guess I hit the button. Moving on, I'll kind of zoom through this sort of quickly. Everybody's familiar with the request is a special exception for convenience store with fuel sales at the northeast corner of North Hancock and 561A. They would have access from North Hancock Road and 561A and required to have cross access to the self-storage facility to the east, which is proposed. I should say that's a proposed facility. Here are the pictures of the architectural. These renderings, by the way, are a condition of the approval, that if it is approved, they are required to these architectural drawings, which are consistent with the Hills motif. Purpose of today's action. Consider the mediated settlement agreement first, then consider the revised special exception application and determine whether the revised conditions adequately address concerns including, and these were the three major grounds that it was turned down for in November: environmental concerns, traffic safety, and access concerns. It says on there, this is a reminder, this is a quasi-judicial matter. The standard is there needs to be competent and substantial evidence to support whatever decision is made. When it's quasi-judicial, that's a way of saying that the council here is sitting like a judge and they're hearing the evidence. It's important because nowadays with AI and the internet and all the things you can get out there, it's harder and harder to figure out what the facts are and what's the truth. It's clear that if somebody said something I saw on the internet, that would not be competent substantial evidence, but something that you've observed as a resident or those type of things, that is competent substantial evidence. But they, as the judge, get to determine and weigh that evidence and then make a decision at the end. I will say there are a lot of people here tonight. This is not intended to be disrespectful. This is not a popularity contest. This is not just how many people are against something. Landowners have rights under the code, and so applying the code to their situation is what they're charged with doing tonight. Sometimes that's a hard job, and they may do things that aren't popular, but I'm sure they're going to do what they believe is correct under the code and is in the best interest of the city. As said earlier, it is not a rezoning. It is a request for a special exception permit. I think that's that on that. Okay. Special exception. I thought it was worthwhile. Everybody talks about special exception. Well, what is it? This is exactly verbatim out of our code. Section 106-2, a definition. A special exception is a use that would not be appropriate without restriction, but which, if controlled as to number, area, location, or relation to the surrounding area, would promote the public health, safety, and general welfare. So that is the ultimate standard that they're looking to apply today. E1, which is also on our code, is important. In granting a special exception, if one is granted, the City Council may prescribe appropriate conditions and safeguards to ensure compliance with the requirements of this chapter and the Land Development Code in general. And that is typical with special exceptions. They almost always have conditions that, okay, you're allowed to do it if you do these things. And that's much of what we're talking about this evening. There was an evaluation, I'll skip through this somewhat, that went through in November. You will remember that the planning staff largely felt that these standards had been met. Safe to say that the audience and the public speaking at the time felt that they had not. Ultimately, the council made the decision that they had not been met at that time and denied the special exception. It's been glossed over a little bit, but it's important to say all of these things are currently, if this were to be approved, it's not just go build a gas station. All of these things are requirements that are currently, without a doubt, in the resolution as a condition. One, it has to meet all the minimum requirements of B1. That's everything like landscaping and buffers and accesses and setbacks and building heights, all those type of things that they have as minimum requirements, plus everything else that's in the PUD. It would have to go through major site plan review. I know there have been a lot of comments about we need curb cuts, we need decel lanes, we need turn-ins here. Most of those type of items are dealt with at site plan review time, and that will be a public hearing, just like you'd have here tonight, if it were approved, and if there would certainly be a major site plan hearing in the future. One of the conditions, though, in the current resolution, and this is a quote, "Traffic shall not adversely impact the neighbors and the public safety." So going through a site plan, that is the standard. So you as neighbors, many of you are neighbors, would be able to cite that as if there's anything in the site plan that you feel would do that. There are conditions in there, and I'll just gloss through generally about architectural. You saw some of the pictures earlier. Signage, specifically limiting the signage. For instance, I know there were concerns about lights and gaudiness and signs. Much of that has been limited and restricted. There's no advertising allowed around the pumps, things like that you'll often see. No outside display of merchandise. They're not allowed to put all sorts of things out in front of the store, except those things that by law they have to, like propane tanks. But they can't have vending machines out there sitting there, so it's a pristine storefront. Utilities all have to be addressed. Water, wastewater, electric, all those things have to be available to the site and are addressed. There's a section on security and facility requirements. Among other things, they have to have surveillance cameras. I know several people have made comments about concerns about crimes and loitering. Loitering is strictly prohibited. There are specific things about lighting and security, dark sky lighting, things like that, so that the light doesn't leave the premises. No pipes or paraphernalia. I know we're a city that has made smoke shops require a special exception, and basically they're not allowed to have bongs and these type of paraphernalia that you often will see at a convenience store. None of those things are allowed to be sold at the store. There's a requirement that they have at all times, at least for safety purposes, 2 employees manning the store, so there's not just a single cashier or register there. The fuel dispensers and aesthetic standards are spelled out in great detail. Those are the same standards, and everything in here, by the way, is typically required of the gas stations that we currently have in the city, the racetrack that we have, and the other one that has not yet been built on 27 went through a similar process. There are also provisions on maintenance, vending, and cleanliness standards. There were several comments about trash accumulating, and there's a whole process on making sure that the grounds are kept clean, or it would be code violations. There's a lot of words there. This is what happens when I do a PowerPoint. Let me break this down. These are some of the specific conditions that are new, that came out of the mediation. So this is one of the first things that dealt specifically with traffic. You'll see the first, let me try to break this down a little bit. The first thing there is that traffic generation and access for the proposed use shall not adversely impact adjoining properties. That's an overriding concern, and the general public safety. Major site plan review and approval by the city is required prior to any use of the property, period. Now, that's the current request that you considered in November. That was the end. There was nothing after that. So everything else after this is new. This specifically addresses access on North Hancock. And in November, there were a lot of folks, particularly Del Webb residents, that were upset because they were worried that a lot of cars would be taking a right turn out on North Hancock and doing U-turns in front of your entrance and all of that. So the applicant agreed to block, so there was no right turn out on North Hancock until such time as 455 was complete, because at that time the road, there's much more of a need to go north, if you will, on North Hancock. At the time of the mediation, that had not occurred. As many of you know, 455 has recently now opened up. So that condition is frankly not that meaningful at this point. This next point, though, is there were concerns at the time on the 561A's time. There was some doubt as to whether or not there would be access on 561A and where it would be. This requires full access. They have to have full access off of 561A. Now, whether or not there be decel lanes and turn lanes will be determined at site plan, but the full access is required. The applicant has, and they'll probably address this when they speak, they have preliminarily from the county been given a full access cut on 561A if this is approved. But if regardless of whether that happens, they also have to give a connection to the neighbor to the east so that you can go through that property as well. But they have to have full access on 561A, and they will also have access on North Hancock. This says, as you say, the location and all these things, because it is a county road, both those, we defer to Lake County as to a lot of those issues, but our requirement is that there is full access for those purposes. The next condition, similar to the first, there were questions about hours of operations. The notion is that particularly at this time, until that area is developed more, it did not want to have 24/7 operations. The applicant did agree to close the store from 11 p.m. to 5 a.m., but again, that was connected at this point to when North Hancock goes all the way through to 455, and it becomes more of a destination from the north. At that time, if desired, the applicant would have the ability to open it for 24 hours at that time. And then this is probably the most significant. All of this, again, this is a lot of words, I realize, but I will defer somewhat to the applicant. I did peek at the PowerPoint that they have, and they go through this in a lot of detail. These are all environmental conditions dealing with the tanks and the issues of leaks and all of those things. Except for number 1, 2 through 8 are all things that are not currently required, frankly, of any of the other gas stations we have in town or by the law. Those are over and above what would be required. Constant monitoring and alarms and all of those systems, has double-walled overspill buckets, those type of things, some of which I don't completely understand as not an environmental engineer, but they'll address these things. All of those things will be required, and the applicant has agreed to those things if it is approved to prevent any concerns of an environmental leakage or concern at the site. There. So back to the same slide. Again, purpose of today's action, consider the mediated agreement, consider the special exception application, and determine whether all of the conditions that were there, in addition to the previous ones that have been addressed, address the concerns and meet the standards of a special exception permit under Minneola's code. So with that, council had some questions.
I had one question. If you don't mind, can you go back to the slide where you had the 3 main issues from the first meeting?
It's right there.
Oh, did he go back already? My bad.
Those on there the last one.
Oh, that one? Yeah.
Environmental, traffic safety, and access. Environmental, I get it. The traffic safety and the access piece, most of those are handled during site plan.
Yes.
Now, hypothetically, this is not a 7-Eleven, this is a Chick-fil-A, which generates a lot more traffic. They would not have to go through this, and that would just get handled in site plan. So ultimately, the challenges, the environmental seems to be the driving force of
I would actually disagree.
That's fine. I'm just asking.
Okay.
But you'll have your moment in a second. So
Yeah.
I'm just asking for my clarification.
Yeah.
Because that's what's important to me, but I'm sure that other things are important to other people up here. I'm just saying that's what I'm focusing on is the environmental piece.
Well, on the traffic safety and access, in particular, if there are concerns that are not specifically provided for in our code, or frankly, if there's just a concern in general, now is a good time to put that
That's
as a
fine.
specific
Absolutely.
condition
Yes.
that has to be done. When that is done, you're correct, when that's actually accomplished, exactly how it will be done is at site plan, but
That's fine. I'm just saying,
if
just
there's
from my
something
point
that
of,
you want and feel is needed,
I'm one
now
person.
would be the time to
I'm
add
just,
that.
my thing is
Yeah.
the traffic and the access, knowing that if it would be in another business, we would still have the same
But you are-
issues.
but you are correct.
That's how it is in my optics, of my eyes. You all have different visions than me.
You are correct. If this was any B1 use, including a Chick-fil-A or something that didn't require a special exception, they wouldn't have to go through this process. The sole public input would be at site plan time. Right.
Okay, thank you. That's all I just needed to clarify. Now, anybody?
Yeah, so and to your point, yes, if it was a Chick-fil-A, I'm sure we would have half the audience here. However, the truth of the matter is that it's not a Chick-fil-A, it is a gas station. And what has been presented to us, especially in the settlement agreement, does have what I call overlap and what I call fluff. So Scott, is now a good time to talk about item 8?
Yes, if you'd like, that'd be fine.
Perfect. So item 8, which is put over here a second.
Wait.
Sorry?
Yeah,
Well, I think we're going to be talking about them together. He'll be bouncing back and forth, so
You will.
Sure, and so do I, that's why.
So
Yep,
let him,
You'll have-
we're
you'll have
speaking, and then we're going to open it up to that, so you'll
Correct.
have plenty of time.
Correct.
No,
No,
we're,
no,
we're,
no.
We're,
Yeah.
we're going parallel paths here.
Yeah. So on the agreement itself, after reading and after digesting it, it has what I call a lot of fluff, right? And to go into that a little bit more clearly, there's a few topics in there, which I'm sure you're going to nod your head a lot saying, yep, 100%. Traffic access, hours operation, environmental, city control, legal resolution. So we'll talk one by one. When it comes to traffic access, this one's a pretty funny one because, Mark, when did Hancock first open? When was the first car available on Hancock?
On Hancock Road,
Yes, going all the way up.
all the way to 455.
Yes, sir.
I don't recall when it was first open.
Ballpark.
6 months ago?
6 months ago.
Maybe.
So we had the ribbon cutting in December. Does that mean that and that was December 19th? Does that mean that on December 19th, a vehicle traversed all the way from 561 all the way to 455? Yes.
It's possible, yes, without doing any research to verify.
Perfect. So that brings up the first point that this resolution or this amendment, the settlement agreement, I should say, really holds no value because why did we sign something on April 9th stating that the road would be open, that it would not allow certain traffic until that road is open? However, that road was open months prior. So that's one. So to me, that does not hold any merit. Right now, it's 0-1, right, when it comes to the counts. Second is hours of operations. So it's limited from 5 to 11. However, again, with Lennar already on its way up, with that extension already built to 455, again, this limits and whitewashes a little bit of what it is that we're getting. So again, this is not a resolution of mediation. This is fluff and this is whitewash that the attorney on the other side tried to push into us. So again, I do not disagree with that one as well. Environmental field safeguards. So this one, it's pretty funny because they did list a whole slew of items on here which looked really good and looked nice. However, out of all those items, there were maybe actually four of them that actually had any new bearing or weight on it. The rest of the items that were on that are already part of the Florida statute, including double walls, including continuous leak location detection, double wall piping, and requirements for leaks and failures. So a lot of those items that were in there as well were fluff that the applicant put in order to make it look big, in my opinion. There are some items in there that they did add to the applicant's, to their favor that they did add. However, a lot of those items like 24/7 remote monitoring by third party. I would like to know who that third party is, how are they monitoring, and who and what exactly are they monitoring, but more importantly, what's going to happen after if a leak is detected? What is the protocol in order to inform the public? This is, again, a mediation settlement that, in my opinion, should not have been signed by the city, therefore should not be right now on our table. Second item would be the spill buckets required. Again, spill buckets required. With the double-walled overspill, I don't think that's really necessary. And again, I can go on and on. I'm just trying to hit on the top points for the environmental side. According to Florida law, periodic and annual testing is required. However, on there, they put monthly third-party inspections. What's going to happen next? What happens after that inspection? I would like to understand what exactly is the next role after the inspection is done. Do we just get a piece of paper and say, okay, great, this is awesome? Or what's the action that's going to be taking place? This is like saying, everything that I've listed here is like you're going to buy a car and the car dealer says, here's your car, by the way, it has an engine. Great, awesome. I was already expecting an engine. Next that I have here, it's what's presented from a city control. It says that what's presented is that city maintains authority and can enforce conditions. However, we already enforce conditions and permitting under our code. So again, this is just fluff that was added in order for this to pass through, which I do not agree with. And that's it. I think that was a big talking point. I could keep going, but I think those are the big items. And the last one that I want to talk about is the traffic. So again, we go back to the first point that I said about traffic and access. Yes, that will be limited until that road is completed, but as I said prior, that road is already completed. The main point of this, and part of the reason why I denied this the first time, is to not impact the residents of Del Webb of cars making a U-turn and going back on Hancock. That is the main reason why I voted no, and I still stand strong as to why I would vote no to this, again, for that reason.
And if I may add to that, thank you, Eric, because that was a lot. For the simple fact that I don't want to repeat what you had said in regards to the traffic. I myself, I voted no the last time as well because of the traffic issue. It is a huge traffic concern. Our city attorney said it was very meaningful with the right turn. No, it is very important. We do have an issue. There is going to be people that are going to be crossing over that area there. And not only that, we have an active community that is there. And I just want, for the record, I do want to put out there that, yes, I do have this from Helene Glatt. I did speak with her. I did also mention her at the last meeting. And again, she brings up very important comments here that just solidifies my issue with a traffic safety problem that we have there. I don't know in regards to the exact amount of vehicle accidents that are there, but I do know for a fact there's a lot more racing that goes on those streets there on 455. We don't have to have a problem when there's just accidents. We have a problem when we have more vehicles on the road. And now with a community that's there, that's a Lennar in the back there, that is also more vehicles that are going to add to it. It is a family community. They do have hundreds of homes and children out there. And if we just go ahead and add this there, again, that's where my traffic safety comes into play. So, thank you for what you had mentioned, Eric, but traffic safety will always be an issue for me, and this just increases it detrimentally, personally. Thank you.
Welcome. Saunders, do you have anything you'd like to add?
No.
Okay. Ms. Flynn?
No.
Okay, there'll be more time for more feedback. Thank you for your input. At this time, the applicant would like to come forth. And his team. Ooh, it's the passing of the clicker. You need to show them how to use it? Well, you're an experienced person now. You're a trainer.
I'm going to save time. I'm not going to use it. Good evening, Mr. Mayor and Council. My name is Richard German. I'm one of the principals of Sunterra Communities, the developer of the Hills of Minneola. With me tonight also is Dan Edwards, my partner. Let me first, I think Mr. Gerken gave us a good history of the events. We decided to file for mediation instead of going directly to court because we thought it was a lot more user-friendly, if you will. And so we did that. Recognizing that you're not bound by the mediator's decision. I want to thank your manager, Mr. Johnson, and Mr. Gerken for doing a great job of trying to work through this with us and represent the city properly. We had 2 sessions of mediation, so everybody put in some time to try to come to a settlement agreement that looked to be fair. I'm not going to go through all my slides. What I am going to do is I'm going to directly to the environmental consultant who is here tonight, Sean, with 7-Eleven. He'll give you all the things that they do and all the clarifications I think necessary to see that it's properly done and the environment is not a problem. And then I'll return and make a few comments.
Okay. Thank you very much. Mr. German.
Please make sure you sign into the sheet as well as state for the record your name and address.
Yeah, let's see here. I got it. Let's see.
Fortunately, your company shirt color is not red, so we're good.
Well, good evening, Mr. Mayor and City Council members. Thank you for having me here to talk about this very, very important project. My name is Sean Flynn. We're going to scroll right. Go through a few. My name is Sean Flynn. I work for Aptum Environmental for the past 32 years. I'm a licensed Florida professional geologist since 2007, and my primary work experience includes project management and coordination of Phase 2 environmental soil and groundwater testing, as well as contamination assessment remediation for petroleum and chlorinated solvent type projects. My clients are public sector and state, and private sector, forgive me. I hope my talk here this evening will in some small way provide you with some appreciation for 7-Eleven's commitment to protecting the environment through their superior construction practices and management of systems once installed. I have 12 slides here. I have my first couple slides are a general description of 7-Eleven's petroleum storage systems, a slide with 7-Eleven's compliance activities that kind of sets them apart, in my opinion, from other companies. What generally happens if a system were to have a failure, and a description of the local geology and hydrogeology with illustrations to show the level of kind of a natural protection that is provided by that. And then there's a slide illustrating contamination potential to the Florida aquifer, and then a quick summary. Okay. Hey. Got a laser. Does this have a laser on it? Yes. There we go. Okay. This is just underground storage tank system. The fuel's going to go in right here at the double-walled overspill buckets. And yes, 7-Eleven it's not required to have a double wall, but they've had failures in the past with their single wall systems. That's why they go to double wall.
Just isn't it a Florida statute to have double walls in every new gas station?
No. I don't
You
believe
sure?
so.
It is, correct? Can someone, do you have the Florida statute for that, or do I need to pull it up?
It is Florida Administrative Code, Chapter 62-761, governing law for petroleum storage tanks in Florida. Double wall tanks and piping is number 1.
That's what I thought. Thank you.
Okay. I stand corrected. Okay, so anyway, you'll fill your tank. We have interstitial monitoring on the tank. Usually that sits at the bottom. If there is a failure of the shell of the tank, you could possibly get groundwater, not at this site because groundwater is very, very deep. So if there was a problem with the interior tank, it would be detected. And then it goes into the submersible turbine pump that takes it up into, and there's a sensor in here, and then it takes it over to the under dispenser containment and into the dispenser system. Petroleum facilities are heavily regulated by the federal government through the US EPA and through the FDEP. Installation can only be conducted by specialized certified petroleum storage system contractors regulated by the Florida Department of Business and Professional Regulation. Just underground storage tank systems, modern underground, pardon me. Here we go. Tank system components and piping are double-walled. Tank system components have leak sensors and alarms, and tank system components are inspected frequently. Here we have some photographs of There's 4 tanks here at this facility, and this is flexible double wall piping, which is pretty typical in today's systems.
So, sorry to stop you 1 second. So let's talk about the sensors and alarms. So once there is a leak underground, what exactly happens?
I've got a slide.
Oh, perfect.
Yep. Okay, below are some of 7-Eleven's compliance activities that sets it apart from its competitors and ensures the surrounding environment will stay clean and surpass requirements set forth by federal, state, and local regulations. Obviously, double-walled underground storage tank systems, that's a standard in the state of Florida. The equipment is maintained by certified technicians using new replacement parts, approved by 7-Eleven, peer review team, and team comprised of engineers.
Right, hold on, I'm going to stop you there again.
Yep.
How does that compare to the standards of the state of Florida?
I think Mr. Hernandez is just going to ultimately ask you, how does this vary from what is required for everyone?
Correct, yes.
So, I mean, just, I see a pattern.
Way to ruin my thunder.
Yeah. I don't have an answer to that. I'm a geologist. I'm trying to get some of this underground storage tanks up
Sure,
here.
okay.
Okay. The gasoline equipment is routinely tested per law by a company called Tanknology, and they're a certified and respected testing company. 7-Eleven contracts with a third party to remotely monitor all the fuel tank monitor alarms day and night, and this is not required by law. 7-Eleven contracts a third party to conduct monthly visual inspections to perform the compliance inspections. Store operators with little fuel knowledge are allowed to conduct these per Florida's rules. And you had mentioned earlier, so what happens if they find an issue? 7-Eleven addresses it. I've got that on another slide. Let's see, they're down here. Sensors are installed in the dispenser liners, the submersible turbine sumps, and tank interstitials for continuous monitoring. And continuous monitoring sense of the sensors is not required per rule. Continuous 24/7 monitoring. 7-Eleven's overspill containment protocol is double-walled. Everybody does that now. 7-Eleven installs only shut-off valves, valve drop tubes for overfill protection. So if a tank were to ever fail, sensors monitoring the interstitial area between the tank walls, the fuel lines, and the under dispenser containment sumps are monitored by an in-store Vita route system, and an alarm will go off in the store. The Vita route is also monitored remotely by Fuel Quest. They're their third-party monitoring and dispatch service located in Houston, Texas. Fuel Quest immediately contacts the 7-Eleven local fueling service contractor to investigate. And then the contractor will contacts 7-Eleven's regional compliance manager, David Peterson, if there's any equipment that could be compromised, or if there is liquid in any pieces of equipment. 7-Eleven's regional environmental compliance manager will contact appropriate authorities to relay situational instructions and compliance information to the service providers. The service providers have authorization and are expected to immediately shut down any piece of fuel equipment that is or appears to be compromised regardless of the objections of the store personnel. They then contact David Peterson to explain why the equipment needed to be shut down. So I had a conversation last week with David Peterson, and he informed me that 7-Eleven has never experienced a catastrophic USD failure. His response was that over his 18 years, They've never experienced a catastrophic event, but he did mention that about 25 years ago, a driller went through a tank over in New Smyrna Beach. So this has greatly changed any drilling that occurs around the tank farms or the product lines.
So, sorry to ask another couple questions, not related to this, it's something related, but not as before. So this David Peterson, so what happens if he's sick? What happens if he's out of office? You know, what's the redundant path that happens if he's not available? And the second question is, hypothetically, say there is a leak. System works, shuts down. Was there a study done to see how long the gas will travel from the leak down to the source groundwater before any action is taken? Or what is the remediation path in order to correct that, if any?
Okay, David, if he weren't available, he would have somebody set up in his.
That was a facetious question, right? The point is that it seems like there's only one person that is responsible for this, right? So I think a little bit more explanation, you know, in my opinion, would have been a little bit better. I do have, you know, and I chuckle when you read this. He says, in the 18 years with the company, I've never had experienced a catastrophic event. Well, the Titanic sank and it was supposed to be unsinkable, right? So point being is that you never plan for something until it happens. And I think that's something where we need to really look into this. More so to Mayor's point from my mental concern, like I asked earlier, if there is a leak present, what is the protocols in place in order to prevent that from polluting potential wells in the area, which this area is full of as well?
Right. Okay, so if there was a leak, and typically they occur at fittings, it's rare that the tank is ever compromised, very rare. I've been doing this for 30 years and haven't seen it, actually.
Okay.
So if there is a leak at one of the fuel product lines, the sensors will detect it. They'll have a response. And if we have to cut concrete, we cut concrete to see the extent of impact to the soil. At this site, it's very, very sandy. So generally, the spills are 5, 10, 20 gallons, and the system gets shut off. You either remove it with a shovel or install some type of a soil vapor. At this particular location, it would be probably some kind of a soil vapor extraction system.
So,
But that would have to be a pretty big spill.
sure. In one of the pictures you had, there was almost like a liner that goes below the tanks. Was that correct?
No.
So,
I think I saw the picture. We can go back, let's go back to the slide. It was like
there.
That one.
Okay. That's a water. That there is water.
No, so on the red tanks?
Yeah. Oh, I think that just looks like Visqueen.
Okay, so that's not
lot
a
of
final
times-
product it's usually in,
A lot of times they'll put that in so if you have rain or weather, the walls don't collapse. It
okay,
keeps-
okay. So that's not part of the final product? in
No.
other words. Okay,
Well, that would stay in the ground, but it's really not a secondary containment.
gotcha. Is there any options, or is that even a feasible option to put a secondary container in order to really contain the leak?
It has been done, but it's obviously a very expensive option.
But it has been done.
But I believe it has been done, yeah. It's some type of high-density polyethylene or something. Okay, so let's get into the local geology and hydrogeology. I utilize the St. Johns River Water Management District hydrogeologic information system to generate geologic and hydrologic cross-sections for the project area. And then we found that the site was very suitable with natural conditions to make placement of this 7-Eleven facility much less of an environmental liability than was implied during previous meetings. And also in April of this year, a phase 2 was done at the site, and there was 5 borings completed to 40 feet. We collected samples for laboratory analysis for some pesticides and herbicides because it was an agriculture area, as well as volatiles and semi-volatiles that are common to petroleum. This is kind of a baseline testing is what it is. And everything at that time was below laboratory method detection levels and Florida soil cleanup target levels. And the water table was not encountered. Okay, so here's a cross-section that was developed using gamma logs. And, oops. And I know you can't see the, it's about a 3.15 miles total width of this cross-section. And what we see, the yellow part is the Lake Wales Ridge. It's an ancient beach dune, approximately 150 miles long by up to 15 miles wide. I think it's about 9 miles wide here. It extends from Highlands County to Lake County. The sand ridge is highly permeable and an area of high recharge of the Florida aquifer, particularly in areas of karst features, sinkholes, and internally drained lakes. The Florida aquifer is light blue. That's a permeable limestone and dolostone unit, supplies most of the drinking water in Lake County. And then we have this green unit is the Hawthorne Formation. It's a geological unit comprised of clay, phosphatic sands, and carbonates. So it's the phosphatic sands that's unique to the Hawthorne, and they mine it throughout the state of Florida for phosphate. But that's what you can barely see. I don't know if you have if you look at the handout, you can see over here where you get a kick in the gamma log, identifying the presence of a Hawthorne. So it acts as a confining layer, an aquitard, restricting the movement of water through the underlying Florida aquifer. It can also be leaky, so we really don't know unless you do an actual boring straight through, right at the site, straight into the Florida. We can, you know, we have this is what geologists do, you know. Let me see here. So based on geophysical logs and the gamma rays emitted from the characteristic phosphatic material, the estimated thickness of the Hawthorne in this area is between 30 and 40 feet. Also based on location relative to the 4 logs, 1.5 to 2 miles in each direction, I agree with the presentation of this cross-section. Then we have what's called the potentiometric surface. There's a little arrow there kind of showing it. The potentiometric surface is the elevation that the water surface would rise in a tightly cased well through a confined aquifer system. Based on St. John's River water management data, the potentiometric surface at the site is approximately 70 feet NGVD. I will state that this is from 2012. That's the most recent data I could find. Things that affect the potentiometric surface are use and drought. So it could be a little lower, but it's generally in the upward direction. So based on the upward rise of the water table, it suggests there is a fairly well established confining unit which should prevent the vertical migration of contaminants such as petroleum, which is less dense than water, i.e. it's a floater. So due to this low density, you typically find in the upper 10 to 15 feet of the water column, wherever it might be. It's greater than 40 feet and at this site. So it has a long way to go to get to the water. Site conditions based on the bottom of the UST positioned at, say, 15 feet below land surface. There are 150 feet mean sea level, and the top of the Hawthorne at approximately 55 feet NGVD. There's an estimated 95 feet of strata. So this works out to approximately 125 to 135 feet to the top of the Florida aquifer. This next cross-section is one going north and south.
Okay, I'm gonna just stop you there just because I don't know about y'all, but I'm kind of getting lost here. Honestly, you probably need to, you're super smart and I get it, but you need to explain this like you're talking to Homer Simpson because I need to understand a little bit. I get it, but it's got to be, you're talking above my head here, and so it's just going to wah-wah. I'm just,
Okay,
you need to make me comfortable on the environmental piece, because
well,
I'm not a
one of
scientist.
the key factors at this site is depth of water.
Okay,
So we've got a heck of a long ways for any contamination to go before it gets to the water, to the shallow water table.
okay.
Now, should it get there, which there's going to be alarms going off and people are going to be going out there and taking care of the contamination, for either digging it manually or installing any kind of a system that would treat the soil, the impacted soil. And also this potentiometric surface is really key because, so if I drilled a well, cased it off into the green hawthorn and went it down into the Floridan, water's going to want to come up. That's the potentiometric surface is where that water comes to.
Okay.
So if I put a well just in the yellow part, we will see where the shallow water table is. And if there's, say, shallow waters at 70, at 40, if the potentiometric comes up to 70 feet, like I noted, and the water table's at, say, 75 feet, you got 5 foot of upward head.
But we're not drilling a well here, we're putting gas in the ground in a tank.
Okay, so
That's what I'm trying to-
should contamination get to that water table, it's not gonna want, it's being pushed vertically, so it's not gonna go down through the hawthorn if it's leaky and into the Floridan aquifer.
So you're saying that there's
Because
an
of that
upward pressure that's going to
upward
be
pressure.
going up, right?
Yeah, the upward pressure
Okay,
of
got
the
it.
aquifer. So that's a really positive thing.
Okay,
Not
thank you for explaining that. I was
Okay.
getting lost in the other part, so I got it now.
Physics 101.
I didn't do physics.
Okay, so this cross-section is really quite similar to the east-west cross-section. So I really don't have a lot to say about that, just that there's consistency out there. And it's key, this hawthorn is key. Whether it's a little bit leaky or whether it's a really tight, gumbo clay, we will never know unless we did a boring right into the site.
And then once you bore into that site, that's how you know the density of the hawthorn?
I'm sorry.
Once you bore, that's how you know the density of it?
Yeah, you could bore right into it and get a sample, and you can send that sample off to a lab and it'll tell you the hydraulic conductivity of it,
Okay.
But it's just the fact that identifying it it's the only way you could do it would be to bore. These next two slides are just the geophysical logs from the very first cross-section. And you can see that kick in the gamma log where I've circled. That's identifying the phosphatic material in that confining layer, known as the Hawthorne Formation. And the next one is the one to the east near Ferndale. You can see that there. That's identified in that geophysical log. Go ahead.
I guess it's just asking the question, because again, I'm not a geologist, and you'll probably help me on this. You're doing all these core samples everywhere. Why didn't you just go to where you were going to put the tank and just do the core sample right there and just say this is what's here instead of this is over here 100 feet or 500 feet? Let's just talk about where it is. Why was that not done that way?
Well, typically, our due diligence is we test the location of the tanks, the location of the proposed dispensers, just to get a baseline.
But neither of these
go that deep. It's just, that was the scope of work for this project.
Okay, thank you.
Never thought it would get to this point, kind of thing.
Okay, thank you.
In hindsight, would have been nice.
Okay, thank you. I was just curious. Thank you for clarifying.
Yeah. Okay, so this next slide shows that a high percentage of the state, the Floridan aquifer system is vulnerable. Our site there is in the red, which is the most vulnerable areas, but does this mean we don't put gas stations in any of these areas? Of course not. At this particular site, we've got these geologic, the potentiometric surface, the depth of water, which really is very positive. If the water table were at 5 feet, things can go south if you have a leak. So, in summary, due to 7-Eleven's system engineering and natural geologic and hydrogeologic conditions, any potential risk to the Florida aquifer or shallow wells is very low. Due to double wall constructed UST systems from the fill port all the way over to the product lines. System maintained by certified technicians and leak sensors installed from the USTs to the dispenser sumps with 24/7 monitoring. Should a fuel leak occur, 7-Eleven would quickly determine the cause and repair it. This would also address the impact caused by the release to prevent further spreading. Again, depth of water is 40 feet. Based on site elevation, 165 feet, and the depth to the top of the Hawthorne, approximately 55 feet. There's about 110 feet of material just to get down to that confining layer for a petroleum release.
So going back to the upward pressure, is that upward pressure constant, or is
Yes.
something?
Well, it fluctuates, but the water management district does monitor that. I don't know why that was a 2012, but like I said, the only things that really affect that are withdrawal and drought.
So what could cause that upward pressure to decrease or increase?
Drought or
Drought, okay.
people's wells, just over pumpage.
Okay, so as the water table goes down, the pressure
Yeah,
releases, so
pressure
that
would
way you don't
drop
have that upward pressure going down, or going up, I should say. Interesting.
And the Hawthorne is estimated to be 30 to 40 feet in thickness. And again, the potentiometric surface is in the upward direction. So in closing, and I don't know if the question will be asked, but, can I guarantee there'll never be a leak? That's impossible. However, if a leak were to occur with the modern petroleum systems, they typically occur at a fitting and are limited to gallons, not a catastrophic event. And should any leak ever occur, it will be investigated and properly addressed to mitigate environmental impacts. But one can be sure that 7-Eleven has a rigorous process in place for system design and operation. And during my 20 years working with 7-Eleven, I've never experienced or heard of a major leak, and can honestly say that they are serious about preventing impact to the environment.
Thank you. Bring it back to council for any questions, or do you want public comment now? Vice Mayor Hernandez, Ms. Flynn?
Are we gonna have the applicant come up? Or do you wanna?
Do you want to?
Public comment.
No, that's fine. You want to add, Mr. Drummond? Okay, that's fine.
So I do have one environmental question. So in all gas stations, you do see where you have pipe fittings that are typically away from a gas station that point up, right? Either that's, I don't know if that's a pressure release valve or a pressure release hose.
These are vents.
Those are the vents, right? So, yes, that's what I thought. But in the event of a leak, do those actually burn off fuel, right? No, so it's not like in like an oil refinery where they actually burn.
No.
In the event, which I'm sure we've all seen it on the internet, where you have somebody pumps gas, they leave their hose, they take off, and the hose goes with the car, there's an emergency shutoff that immediately initiates upon disconnect of the hose with the station. Is that correct?
That's correct.
And there's no leakage that can, besides a few drops, sure, but
We get maybe 2 a week, we call immediate responses in Central Florida. And people drive off with that hose, wagging out the back, or we had one run into a dispenser last weekend in, I think it was the Longwood area. And, it went across the pavement, it went down the little flume where, stormwater would go. So what we would do, and what we did, is we go out there with shovels, and it's very low tech, and dig out that soil and test the horizontal and vertical limits of the excavation to make sure we get it, and then collect samples and send them to the lab. And the soil gets disposed of at proper facility.
One question, I don't think it's been asked before, and maybe the applicant will know the answer to this out of curiosity. Will diesel be offered at this station?
I don't know. I noticed the slides that you had that said fuel, and typically that's gasoline.
That's right, okay.
So I would say, I don't know.
Okay, and from an environmental cleanup perspective, is fuel and diesel, are they valued the same, or is diesel considered more impactful to the environment?
Well, it's just a little more difficult to clean up. It's, doesn't tend to migrate because it's a heavier product,
Right.
like gasoline.
Mhm.
So it's just a little harder to get off the soil. It tends to absorb to it more than the volatile gasoline.
And then another question that's more be for the applicant as well. A lot more gas stations, particularly those located by lakes or bays or oceans, et cetera, are now offering rec fuel, right? So no ethanol. Is that something that will also be offered at this gas station, or is it strictly just the 3 tiers of fuel?
You mean the high sulfur? Red, you said red?
Rec fuel.
Rec
So,
fuel.
yeah, so no ethanol fuel.
Oh, yeah, I don't know. I don't know.
We don't know the, okay.
Mr. Chairman?
Is that it?
Yeah.
Thank you.
I could talk to you all day about geology, but I'm sure the crowd here does not want to go to sleep just yet. But
Thank you. I'll give you my high-level environmental report. 7-Eleven operates over 8,000 fuel dispensary operations in the U.S. I think it's clear to say they know what they're doing in terms of the environment. Any environmental catastrophe would be so financial damaging to that company that's why they go 3 steps above, I think, any requirements that may be made just to protect themselves. I want to just touch on the traffic issues. You know, when we started this process, Hancock Road was not open, only to Del Webb, and that was it. So it sort of felt like Hancock was an entry road for Del Webb, and I understand the concerns for U-turns and so forth, because that wasn't any other place to go. There was no other traffic going farther north. Now there is, it's fully open. But in order to deal with that, we can't get a full turning movement. I think we've been through that at this location on Hancock because it's too close to the light. But what we can do, well, we've asked the county if they would let us put a U-turn, no U-turn at Del Webb. They have told us initially no, but we can still go back and try again. We might be able to build a U-turn facility in the road further south, but not still far enough from the traffic light, but I can't commit to that because we haven't talked that over with the county either. But what we can commit to.
So you mean further south from the turn into Del Webb?
Yeah. What we can commit to is appropriate signage directing people that if you're going to go south on Hancock, you exit here, not there, not to the north. And we'll have north. This is a north exit only. No, do not take this exit if you're going to go south on Hancock. So we can at least try to mitigate some of that, I think, by signage on site. But we're not going to give up with the county yet either, so we'll see if we can solve some of that problem. As I said also earlier, we went to mediation to avoid any kind of court proceedings, which we still don't want to do. And hopefully this will resolve itself. I think you as a commission have sort of set the stage that I don't know how to get another gas station approved. If based on your environmental requirements and so forth, I'm not so sure you can ever get another gas station approved in the city. So we are concerned about that because obviously we have another one down at the town center that will be coming someday. So I appreciate your attention. I gave out the full slide presentation. I don't think you want to watch all that because you've seen it. It's in there, all the renderings and so forth. So with that being said, we hope you support getting this approved. We're dedicated to doing a good job. If you got any questions of me, I'm happy to try to answer them now, or you can start your public comments.
Yeah, we give you you can reserve the right to comment after the public too.
Okay, you're gonna let me rebut?
Yeah, that's fine.
Okay.
Any questions for Mr. German at this time?
Not at this time.
Oh, Mr. Drummond, I have one. For full transparency and disclosure, I did talk to Mr. German about the project. I did have a couple questions. The reason for the denial, we had the environmental concerns, traffic concerns, and the third one was a formal agreement between adjacent property owners to ensure proper access to County Road 561A. Has that been completed?
Yes.
Okay, thank you. That's all I have.
Thank you.
I mean, just let me add one thing on traffic. I think somebody mentioned it earlier, if we put a Chick-fil-A there or something like that, there's gonna be more traffic, and how do we stop the U-turns for that? I mean, it's just a situation. We're gonna have to do it with signage, I think. Thank you.
Thank you.
Full disclosure, I also did speak with the applicant as well.
I think
We all did.
I've talked to the applicant. So, okay, bringing it back to
Public
council, public comment. Just the ground rules on this. I'm gonna not hold you, just be respectful of time, and I'm not gonna say speak once, but just don't, please make it a revolving door that you keep commenting after everybody else. Just, no, we're all adults, especially you. You're the biggest adult of them all. Thanks.
A couple of things. I'm going to get up and speak to item 8, which was originally on the agenda, then item 9. Juan Camacho is going to go before me on item 9. So I just want to address 2 items here just a little bit. I quickly scoured the internet, pulled up sites, newspapers. In the last, since 2024, at least 5 incidences have come up with 7-Eleven having fuel leakage. So don't tell me in the last 10 years there's been none. Again, oh, by the way, Clinton Pownell, 14205 Hunter's Trace Lane, as if you didn't know. Unincorporated interlocal services, boundary area of Lake County. I also want to just go ahead and proceed on with what I wanted to discuss about, and I'm going to touch upon some of the things that Commissioner Hernandez was discussing, and that's the focus specifically on whether the mediated conditions actually function as intended or whether they can be relied upon for support approval. At first glance, the conditions appear to add structure and mitigation, but when you look closely, several of the key limitations are either an appearance of limitation without substance, an illusion, if you will, or they are already triggered or deferred for future review. First, the conditions rely heavily on the extension of North Hancock Road as a future event that limits both access and hours of operation. However, that extension was already completed prior to the mediation being finalized. In fact, a ribbon-cutting ceremony was held on December 19, 2025, and a number of you were already there, as I saw on Facebook, on the internet. So the condition, as framed as a restraint, dissolves upon contact with reality. And that matters, because the conditions are written in a way that they automatically convert that once the roadway is operational, and the practical effect is that the project would be allowed to operate with a full access and 24 hours operation immediately upon approval. The temporary limitations are not actually functioning as limitations. Second, the critical elements of the project, such as the driveway location, circulation, and access configuration to 561A, are not resolved here tonight. They are explicitly deferred to a future site plan process. Now, what I have here for you are handouts that you have one for the city clerk and 5 more for you. And what these are, if everybody can hear me back there, these are the revised language as it stands in the resolution and why they don't stand. So, again, right now, these are not explicitly deferred for future site plan process. Later is when they're defined, which is to say, not here, not tonight. This council is therefore asked to approve the use without the benefit of seeing how it will actually function in the real world, without knowing precisely how traffic will move, without knowing how adjoining properties will be affected. And these are not minor details. These are the very mechanics of impact. Still further, third, even the architectural identity of the project remains unsettled. The language allows for changes in corporate branding and visual character, which introduces additional uncertainty about the final disposition of the project. What is presented is not a fixed proposal, but a concept, one that may evolve after approval beyond the scope of what is before you here now. Taken together, these conditions do not confine the project. They do not define it with the certainty required for a quasi-judicial decision, for special use exceptions, and instead they defer, they assume, and in some cases, they evaporate entirely. And that brings us to the essential question before you on item 8. Can these conditions be relied upon, truly relied upon, to support the findings that you are required to make? In my view, they cannot. If a condition is already satisfied before approval, it offers no protection. If a condition postpones key impacts to a later stage, it offers no clarity. And if a condition allows the project to change materially, it offers no certainty. In light of what appears to be mitigation becomes something else entirely, an appearance of control without its substance. For these reasons, I respectfully submit that these mediated conditions do not provide a reliable or legally sufficient basis upon which the required findings can be made, and that I ask you to decline when you rely upon them. Thank you.
Sorry I stole your thunder a little bit with my comments.
Thank you very much.
Yeah.
Good evening, Juan.
Good evening, Council. Juan Camacho, 753 Minneola, 753 Rioja Drive in Minneola. You all know who I am. You all know what I've done. But for the sake of the record, 15 years attorney, land development I've done. Been on the zoning board up in the Commonwealth of Pennsylvania for 5 years, assistant city attorney and assistant county attorney in Lehigh County, Pennsylvania, and Allentown, Pennsylvania. And now I reside within the city of Minneola. So I want to do 4 things, and I want to add a couple of things onto those 4 things based upon the evidence that was presented by the applicant's engineer or environmental professional. First, I want to talk about the legal standard that applies today, because I don't want to make that, I want to make sure that we're not glossing that over. The burden of proof. Third, the criteria that needs to be used by City Council making this decision. And last but certainly not least, my final thoughts on the subject. So the legal standard is expressed within City Ordinance Section 106.2A, which requires that a proposed use, when it comes to a special exception application, must advance the general welfare, promote public safety, and promote public health. So safety, health, and welfare. When we're talking about the public, we're not talking about transients, we're not talking about passerbys, we're not talking about people that come on and off the turnpike, we're talking about the residents within the city of Minneola. The burden of proof, more specifically the burden of persuasion. And when it comes to the burden of persuasion, the applicant bears the initial burden to persuade you that the application put before you advances public health, public safety, and welfare. City Council's job is not to prove up their case. It's not the opponent's job to prove up their case. It's their job to prove up their case. And assuming they don't satisfy that burden, the resolution that's before you has to be denied. But let's just say for the sake of argument that they do satisfy their burden, the burden of persuasion shifts to anybody that wants to speak in opposition, i.e. the people that are wearing red shirts today. If we can satisfy the burden to demonstrate that there is competent and substantial evidence saying that there is no promotion of public health, public safety, and general welfare, then the application should be denied. But let's define competent and substantial evidence. I mean, I appreciate Scott's definition, but I want to give my definition. Competency needs to be credible. It needs to be believable. It needs to be substantiated. Substantial evidence has to be weighty. What I've heard today, based upon the application's presentation to City Council, nothing that's been presented has been weighty, hasn't been substantial, and it hasn't been competent. I'll give you some examples. When asked about what the regulations were as far as double walls, what was presented to you was one thing, but then, oh, I stand corrected, it's something else. How is that credible? How is that competent? When it comes to saying, oh, there hasn't been any catastrophic events that we know of, but I heard it from somebody else that's not here. That's hearsay. That's not competent. That's not substantial. Engineer doesn't know about certain restrictions or regulations in regard to underground storage. I don't know is not competent. I don't know is not substantial. You can't use that as evidence. Ordinance Section 106.2E2, contains the review criteria for special exception uses that the city council must consider. One of the big ones is safe traffic generation. All I've heard, based upon the applicant's presentation, is that we need to talk to the county and we may possibly put signage out there. Might, maybe, possibly, probable. How is that substantial? How is that competent? If it's based upon a condition that hasn't happened yet, how can you make a decision based off of that? And going on, section 1062E2 says that the evidence that needs to be considered by this council can be including but not limited to. So we don't have to also just have to talk about traffic. We don't have to only talk about access. We can talk about other things. So based on my humble experience as a land development attorney, for public health, we can talk about the environment. Let me kind of hang around on that one for a little bit. The evidence I heard was based upon 2012 data for a geological cross-section. Last time I checked, that was 14 years ago. Mayor, you asked the question, how come you just couldn't go there now? Wouldn't that be more credible? Wouldn't that be more competent evidence, substantial evidence to be using for the decision for city council today? If it was so important to 7-Eleven to be able to present the best evidence, why didn't they bring it? Diesel fuel, is it being used? I don't know. Rec fuel, I don't know. That's not competent. That's not substantial. Potable water for public health, sanitation and waste for public health, hazardous materials for public health, which is all going to be competent, substantial evidence you're going to hear from the opponents of this application. Public safety, let's talk about traffic, because it hasn't been talked about yet. Let's talk about stormwater. Let's talk about fire and public safety services. Let's talk about structural safety. Let's talk about the general welfare of the public. Compatible, is the uses compatible? Have we heard anything about that tonight? Not yet. Orderly growth, resource conservation, property values. So my final thoughts on this, and I think I've made it clear. I am against the application. It is not the government's job to build up the applicant's case. It is not the opponent's job to build up the case for the applicant. If they don't know, then by far you shouldn't be able to make a decision based upon lack of evidence, lack of knowledge. If there's anything that's going to be said later on tonight or has been said in the past, whether this gas station is needed or whether it's convenient is immaterial. It's irrelevant. Ask the applicant directly, what's changed since November 2025, other than there being mediation, other than being a procedure before a magistrate? Nothing's changed about that land. Nothing has changed about the surrounding area. Oh, the highway opened up. Does that change the fact that this particular use, proposed use, advances the general welfare and the public safety and the public health of the community? I think not. And I sense that there may be a fear, okay, what's the next step? Maybe litigation. It's okay if we get litigated. It's okay if we get sued. I'm just putting my litigator hat on. Courts defer to municipal decisions when it comes to land development use, as long as there's competent, substantial evidence. We heard what the applicant had. Now I want you to hear what the opposition has. And at the end of the day, at the end of this evening, I just ask that the city council is consistent, persistent, and that you're resolute in the decision you made back in November 2025, which was denying this application. So I just ask you, keep the mini in Minneola, and I thank you so much.
Just for the record, before I begin, there were some questions whether or not about Sean Parks and the fact that I introduced an email to him. I have a text here from Sean Parks. He told me in his capacity as county commissioner and scientist, he says that he is objecting to this gas station, and he says, I have his permission to express his objection, and he put a happy face. So I'm just going to let this know because he does have, I think, his master's in environmental and engineering. And I did bring him up as evidence on questions that I had asked him as a specialist, not as an expert witness, and submitted that document. Again, my name is Clinton Pownell. I reside at 14205 Hunter's Trace Lane in unincorporated Lake County within the Interlocal Services Boundary Area, the ILSBA, a joint planning agreement between Lake County and the surrounding municipalities, including the city of Minneola. I have lived in this area since 1992. My family's home on Sugarloaf Mountain has been there for more than 25 years. Because of the ILSBA protections, the surrounding area is expected to retain its rural characteristics for the next several decades. That means more than 1,000 nearby residents, including my family, will continue to rely on private well water as our primary source of drinking water for many years to come. I respectfully oppose the revised fuel component of Resolution 2025-17. And I respectfully ask this council to independently examine whether the revised mediated conditions truly resolve the concerns already established on the record. The fact that the parties have reached a compromise in language does not, by itself, establish compatibility. It does not satisfy the city's special exception standards, and it does not automatically mean the required findings for approval can now be made. The revised language may regulate operations around the fuel station, but it does not answer the central question before this council. Is this an appropriate location for underground fuel storage in one of the most environmentally sensitive groundwater regions in Central Florida? I have a packet for each of you, of course. They're a little out of order. Exhibit A is the second document, and that is a picture of a map. And what Exhibit A shows you, by the way, I did pay attention to, as a Florida-educated and Florida-born resident, I did pay attention to all those years of taking Spanish and learning about the aquifer. So I have on here this picture of a map, and you see where the red arrow is? That is the Lake Wales Ridge aquifer that the previous expert witness was identifying. As you see, I have a nice clear picture of it. And you see that red arrow right there? That's the proposed gas station. You know what else that is? The start of the Lake Wales Ridge aquifer. Now, I'm not an aquifer expert. I am an engineer, though. Last I checked, water runs south. You ever heard of why all the poor people always lived on the south side of the tracks? Because the clean water was always north of the ridge. It starts here, and it flows. And by the way, to answer your question about the up and down, he's absolutely right. It's due to the pressure. And what's going to decrease that pressure? Flowing south, and by the way, flowing into Lake Apopka, which we have spent as a community thousands of dollars and tons of time and resources cleaning up. And all it's going to take is one fuel tank to destroy it and put us at risk. I've also provided the council with a brief hydrological handout. That's the first handout, summarizing government and scientific studies with site sources, identifying Sugarloaf Mountain in Minneola as regionally significant aquifer recharge terrain. It directly connects to the Florida aquifer system. The handout also explains the important distinction between recharge areas and high recharge. And thanks to the expert witness, I don't need to explain what high recharge is. We know it's high recharge. And this is where water moves into the aquifer system rapidly and with far less natural protection. The Lake Wales Ridge stretches roughly 150 miles through the center of Florida, beginning at Sugarloaf Mountain, the highest point, and water entering the ground in this region does not simply remain beneath this parcel. It becomes part of the broader Florida aquifer system, and that supplies drinking water to communities far beyond Minneola. The proposed site is predominantly composed of Class A soils, and you can see that on Exhibit B. And if you take a look, I've given a nice color documentation there, and you can see by the red arrow exactly where the gas station is, and that is a Class A soil. These are deep, excessively drained sands with extremely high infiltration rates. And I live there, believe me, you pour a glass of water on there, it's gone. You run a water hose, 2 minutes later, you don't even see signs of water there anymore. And these are among the most permeable soils found anywhere in Florida. According to Lake County's own mapping, Exhibit B, these soils allow water and contaminants to move rapidly downward into groundwater system because there's very little natural filtration confinement. And the revised mediation language does not change any of that. It does not remove underground fuel storage. It does not remove petroleum products. It does not change the site's high recharge characteristics. And it does not change the fact that the surrounding rural residents, including myself, rely on private wells for drinking water, irrigation, livestock, and agriculture. This remains a living rural community. Nearby properties maintain horses, cattle, chickens, gardens, and fruit groves. We have horses. My neighbors have chickens. Ben McLean, you know, Uncle Matt's father, he still shares fruit from his grove with the community while teaching local families about organic agriculture. This is right around from my house, by the way, and he's on well water. And for those who are not familiar, Uncle Matt's is the nationally recognized, family-run, locally sourced organic citrus producer that is based here in Minneola and Claremont. They also have sales in Whole Foods, Publix. This is not a fly-by-night orange juice operation. We are in a sensitive, rural, residential environment whose quality and sustainability depends directly on groundwater quality. Now, modern fuel systems may reduce risk, but they do not eliminate risk. These protections are baseline requirements for every fuel station in Florida. There is no evidence that this specific location is appropriate for fuel operations, as admitted by the expert witness, and that this is the responsibility before the council tonight to determine this, not merely whether the project can technically function, but whether this location satisfies the public health, safety, and general welfare standards that are required for special exception under the city's code. And the word promote precedes that. In other words, you have to make it better. Promote it, not decorate it with a risk. Given the site's high recharge conditions, highly permeable soils, regional groundwater significant, and surrounding well-dependent resident properties, I respectfully request that the required findings for approval still cannot be made. And for those reasons, I humbly request denial for the fuel component and denial of Resolution 2025-17 as revised. I have also given you additional paperwork. As you can see here, I have data that was started in 2011, and thankfully, because of the delay, it has been updated as recently as April 2026. And it shows two things from the EPA.gov on the internet. Number one thing it shows is there are still 54,000 tanks that have not been resolved. And it also gives you a timeline because unlike the last bit of evidence I submitted from the EPA, I delved deeper into the same articles. The second one I've given you, right in that article, was exactly Florida. Out of Florida, 47% of leakage at gas stations have resulted in groundwater contamination. 24% are soil. With the fast permeable soil of Sugarloaf Mountain, I'm just going to add those two together. 71%, almost 3/4 of fuel station spills affect the groundwater and the soil. And as we saw, 7-Eleven is not above any of that leakage like anyone else, or as we heard. And the final map, again, just substantiates what the EPA has updated as of April, the number of tanks and underwater storage that have leaked.
Thank you very much.
Just one correction, the St. John's actually flows north.
I'm sorry, what?
The St. John's River actually flows north.
Does it really?
Yep.
Thank you for that
One of
information.
the only river in Florida that flows north.
Thank you.
Because it's trying to get away from Miami.
That's true.
Yes, ma'am.
Good evening, Mayor Kelly and members of the City Council. Thank you for the opportunity to speak to you tonight. My name is Cynthia Owens, and I live at 2819 Purple Meadow Court in Delwood, Minneola. I am here as a follow-up to my prior comments regarding the proposed 7-Eleven development at Hancock Road and 561A. First, I want to acknowledge and thank the city and the applicant for working towards a compromise. The added conditions for enhanced monitoring of the underground fuel system is meaningful and appreciated. However, my core concerns still remain unchanged. This project places a fuel station directly over a highly sensitive recharge area, the Floridian Aquifer, as previously noted by prior speakers. This aquifer is a primary source of drinking water for most of Floridians. The limestone geology and sand beneath this site allows contaminants to move quickly through fractures, voids, and sinkholes. In this kind of environment, even a small fuel leak will migrate rapidly into that groundwater. This risk is especially serious because of the nearby private wells. Many of those residents rely on that groundwater for drinking with no continuous monitoring for safety and implications of that gas should it spill. That means this contamination will go undetected until it has a human impact on their health. While monitoring systems are helpful, they are also very reactive. They detect contamination after it occurs. They do not prevent it. And once compounds like benzene enter that aquifer, they can persist for decades, and cleanup is extremely difficult, costly, and often incomplete. And those costs borne by the taxpayers and not necessarily by the companies, since the companies can go bankrupt. That leads to an important point: financial risk. Groundwater contamination can result in significant long-term costs for cleanup, water treatment, or alternative water supply. Those costs often leave, as mentioned, the taxpayers on the hook. There is also a life cycle concern across the country. Fuel stations change ownership or close, leaving behind those underground systems, and often cities are forced to mitigate those tanks that are left behind. Given all of this, I respectfully ask the council to take the following actions. First, require a comprehensive, independent hydrological study conducted by a qualified third party. This study should evaluate the groundwater vulnerability and be publicly reviewed before any final decision. The applicant presented their own study today, but it was not done independently, nor was it publicly reviewed. Therefore, a new study should be conducted. Second, seriously consider whether fuel storage and dispensing is appropriate at this location. Commercial development may make sense here. It's zoned for it, but a gas station introduces a level of risk that may not be compatible with this site. And third, while I do not support this project, should the City Council decide to approve this project in any form, whether it's tonight or at a future meeting, require a financial assurance bond or escrow held by the city, specifically dedicated to groundwater contamination response and cleanup. This bond should be sufficient to cover the worst-case remediation costs and remain in place for the full life of the fuel system, including after closure. This ensures the financial responsibility does not fall on the residents if something goes wrong. I understand the desire to resolve this matter and avoid litigation, but some risks cannot be fully mitigated through conditions alone. They are inherent to the use, especially in the sensitive aquifer recharge area. Responsible growth means not just improving project design, but ensuring the use itself is appropriate for the location. And in this case, protecting our water resource is a public health consideration that the council should seriously consider. For these reasons, I respectfully urge you to deny approval of this agreement due to the very high risk of public health, safety, and welfare. Thank you.
Thank you very much.
Thank you.
Good evening, Kevin Carey, 20237 Sugarloaf Mountain Road. Like Clinton, I am one of the Sugarloaf residents who is on a well, and I would be affected by any kind of spills that were here. So first off, this was brought to P&Z in September 2025. I spoke out against this, number one, because there's a well within 500 feet, and Florida statute says within 500 feet you shouldn't have any fuel tanks. So I question how that can be possible. Number two, just to kind of go through some of the items that were brought up tonight. Last night, we talked to the council for the RV development that's to the east of this development. They said they have not heard from the applicant. So there's been no communication done with them. So that's one thing that needs to be followed up on. They're saying that they haven't been communicated with and they don't know anything about it. So that needs to happen. Next, since we mentioned tonight that there is no guarantee, we cannot guarantee a leak. If this was your house and you live within 500 feet, would you want to have a spill? Because if we have a leak, where do we get our water from? That's one of the main things that I think people need to consider. And lastly, talking about traffic safety, one of the things I spoke out against for this one is the traffic numbers from the study that were done, at least on 561A, the traffic turning left into the development and the traffic turning left onto Hancock Road on 561 can't occur in the same place without widening the road. County doesn't have any plans to widen the road, so therefore I question how you're going to get all this traffic without backing everyone up on 561A into Hancock. That's not going to work too well. We also talked about tonight about how to deal with the U-turns. It was mentioned about providing a turn lane on Hancock Road just north of development. That won't fit. It won't work. You're going to put a turn lane into a vertical and a horizontal curve. Not the best idea. You make safety worse. Not a good idea. As a licensed professional engineer, I've seen it 100 times. It never works. So I don't think that's a good idea. Signs don't always fix everything, so that's not really one of the solutions we should promote. If you're going to turn south on Hancock Road, you can come out onto 561A and make the left turn. but in that case, that creates more traffic on 561A trying to turn left onto Hancock Road. So that makes more issues. And then if we see issues, we should deal with them now, not wait till final plans, because that's when I get involved and start reviewing these. And if we know it now, that should be dealt before it gets to P&Z and not just wait till kick the can down the road. Don't need to wait. Let's deal with it now. Thanks.
Thank you.
very much.
Good evening. My name is Doug Beck, and I reside at 1105 Western Blue Way, Minneola, Florida, and I oppose this resolution due to its negative impact on safety of the residents and lack of compatibility in the surrounding area, same as I testified in November. First off, Florida leads the country in cycling-related deaths, 5.7 per 1 million, and a national average of 2.3. I cycle extensively from Ocoee to Groveland, all throughout the Minneola and Claremont area as well. And the entrance location on the eastern side of Hancock is a significant impact to the safety of cyclists, pedestrians, utilizing the North Hancock extension, which is also part of the Lake Apopka Loop Trail. One of the most exciting developments in Central Florida, also part of the Cross Florida Trail. That trail is part of the key vision of the city of Minneola and the hills of Minneola. That trail serves two key purposes. It's a connector for residents, such as school children and the residents here who travel down to community events, farmers markets, kids going to Minneola Horizon Academy, Lake Minneola High School, and it's a destination point. It brings activities to the community. We just had the FOLA 40, the Friends of Lake Apopka 40 ride around the community, and people got to experience Minneola. The applicant's traffic study defines the peak traffic hours. Morning rush hour. The traffic comes from the west on 561A, heading into the east, morning sun. We've witnessed people run that traffic light because they can't see it. Normally they turn south and go down Hancock and they don't disrupt us. But as exists in this proposal, they're going to turn left, where they then have to go immediately right across the full lane of traffic, across the bike lane in the roadway without running somebody over going to do Sugarloaf loops, turn across the pedestrian trail with kids going to school in the morning, and into the facility. Now, what we know is that 64% of the deaths on cycling occur away from an intersection, and 60% are caused by the interaction of a car and a cyclist being able to yield to each other. They get at this decision point where they're looking at you, you're looking at them, and nobody can decide what to do, so they collide. This traffic flow, if they exit on that, is going to take them back out onto the North Hancock extension, and they cross a pedestrian crosswalk 6 times getting back to Hancock. Come out to the right, go up to the corner, across the crosswalk, turn around, come back across the crosswalk, come back through. All of that interaction negatively impacts the pedestrians, impacts the cyclists. My wife's an avid walker. We've almost been hit multiple times at all of those corners by people who fail to yield at the stop sign, who run the traffic light, and who don't see us while they're turning. The applicant previously declared the area a fuel desert. We don't need a fuel system up there. There's one right down here. There's multiple proposed in the area. I advocate that the developer work with you guys. You have several proposals in process. Locate it where it belongs, near the turnpike, in the correct area. And I want to close with one last thing. The Hills of Minneola Community Vision, it states, and as I stated before, the Hills of Minneola will be a healthy, active, and appealing mixed-use community where families are raised, children can walk to school, adults can live near their jobs, and all segments of the community can live, work, shop, and play together. And these residents want to be able to use that trail without a fear of being run over by somebody trying to get coffee and fuel in the morning on the way to work. Thank you.
Good evening. My name is Andrew Scher of Evening Summit Circle. I'm here to address, like everyone else, the proposed construction of a 7-Eleven gas station approximately 300 yards from the entrance of our community and in a rural residential border area. I'd like to focus on 4 considerations: compatibility of use, orderly growth, resource conservation, and property values. First, compatibility. A 55-plus community is designed to provide a quiet, safe, predictable environment. A gas station introduces increased traffic, extended hours, bright lighting, noise, fuel deliveries, and a higher volume of transient activity. These are fundamentally different than the proposed, than the community requires. Placing them so close together creates a clear mismatch that undermines the character of our neighborhood. The need for a special exemption itself highlights that incompatibility. Second, orderly growth. Minneola has grown thoughtfully, and residents value that. Development decisions set precedents. Approving a use of this intensity at a residential entrance signals that buffers between commercial and residential areas are flexible rather than intentional. Orderly growth depends on maintaining clear, consistent planning principles that protect residential livability. Third, resource conservation. Beyond the environmental concerns, which were so well addressed here, like storage and runoff, there are impacts to the infrastructure of daily life. Increased traffic at key residential entry point will strain local roads, as you've heard, raise noise levels, as you will hear, and reduce safety for pedestrians and cyclists. This is real. The very question of whether an existing tractor trailer, the delivery trailers, can make a right turn onto 561A without crossing into oncoming traffic, or for that matter, exceeding the width of those two lanes without getting onto the shoulder of oncoming traffic, clearly highlights the concerns. I don't know that the applicant has studied that or shared that. Have they? Finally, property values. It's always property values, right? A home is a major investment. Proximity to high traffic commercial uses, especially gas stations, can reduce desirability and negatively impact property values, even based on perception alone. In closing, this is not opposition to development, but a call for the right development in the right place. I respectfully ask the council to consider whether this proposal aligns with Minneola's planning principles and long-term vision, especially that these same concerns were recognized and the application rejected by the Planning and Zoning Commission and this very council 6 months ago. Thank you for your consideration.
Thank you.
Good evening, Mayor and Council.
Good evening.
A little taller, sorry. Good evening, Mayor and Council. I want to thank you for the opportunity to speak. My name is Dwayne Smith, and I live at 2767 Purple Meadow Court. Approval of this settlement requires the city to consider their duty to promote the public health, safety, and welfare of the community. And while various people have or will speak to other areas of concern, my comments are focused on the environmental issues of noise and light pollution. The spring of 2022 issue of Harvard Medicine states noise pollution is more than a nuisance, it's a health risk. One of the major areas that contribute to health risk is the disruption of sleep. The Center for Occupational and Environmental Health observed that noise activates the sympathetic nervous system, leading to fragmented sleep and reduced total sleep time. The American Public Health Association stated that chronic noise, even at low levels, can cause annoyance, sleep disruption, stress, and premature mortality. So what is noise? Daniel Fink, in his presentation to the Acoustical Society of America, tells us that noise is unwanted and or harmful sound. I feel confident in stating that the residents around this proposed service station will find that the sounds they hear will be both unwanted and harmful. He goes on to compare these unwanted sounds to secondhand smoke, in that while people generating the sound may enjoy or desire it, that is not the case for others who find that sound unwanted and harmful. For example, think of being next to someone at a stoplight who is blasting their radio and amplifying the bass. They may enjoy the sound they're generating, but most, if not all, of the people around that car just wish it would go away. Not only do they wish with the sounds to stop, but likely they're becoming agitated and possibly increasing their blood pressure and having some anxiety. My wife and I lived in a residential area that was about half mile from a gas station, and our life there was miserable, and we eventually moved. And the house we are now in is just over a quarter mile from the proposed station. However, there are and will be homes much closer, with one whole court only 600 feet away. Even now, I can mentally envision the noise from the station. Traffic noise of the cars stopping by, loud music cranked up, people fighting, yelling, cars honking, promotional videos at the pumps, supply trucks idling with deliveries or garbage pickup, and then the incessant beep, beep, beep that we all hear every morning as they back up, and likely some occasional police activity. It's not how I envisioned my retirement. Along with the noise pollution with this gas station, they will generate light pollution. Dark Sky International defines light pollution as the alteration of natural light levels in the night environment, produced by the introduction of artificial light. Light pollution comes in many forms, including sky glow, light trespass, glare, and over-illumination. Much has been written about the effects of light pollution on both nature and mankind. Light pollution has effects similar to noise pollution on the human body, including impacts on sleep. A study on the effect of light pollution on the human body stated humans' alterations most described were sleep disturbances, circadian rhythm, melatonin, and cortisol alterations. There are ways to combat light pollution, particularly through the use of dark sky compliant fixtures. However, none of the mitigation factors are mentioned in either the settlement agreement or the red line version of the resolution that I saw. Further, while light pollution may be mitigated, there is no effective way to combat the noise pollution, except to prohibit operation of hours of 10 p.m. to 7 a.m., which is what's identified as the standard for commercial establishments adjacent to residential areas in Minneola's Code of Ordinances. And I know they did 11 to 6 or something like that, which would be similar to that. So I'm asking that you consider the health risks to our community that will occur as a result of the noise and light pollution that will be generated by the station and how it will affect the public health and welfare. I thank you for listening to my comments, and I will give the city clerk the full place with all the citations on there.
Thank you very much.
Just as a last thing for you, I think that the guys at Chick-fil-A have a better site team, and if they looked at the site, they'd say, it's not appropriate for our business, which we would expect the same to be from 7-Eleven. So thank you.
So I'm not quite as tall. Good evening, Good evening, Mayor Kelly and council members. My name is Jeffrey Kapolovitz. I reside at 2762, Lockbridge Road in Del Webb, Minneola. I'm going to follow up on what Mike had to say and talk specifically about Minneola's noise ordinance and why it makes a 24-hour gas station fundamentally incompatible with this location. Minneola's noise ordinance, found in Chapter 30, Article 4, was enacted in its own words to protect, preserve, and promote the health, safety, welfare, peace, and quiet of the city's citizens. It is a preventative ordinance designed to stop harmful noise before it affects residents. And when you apply the standards to a 24-hour gas station located within a few hundred feet of homes, the conflict becomes unavoidable. The ordinance begins with a clear prohibition. It states, the creation of any unreasonably not loud, disturbing, or unnecessary noise in the city is prohibited. It goes further, saying noise that is detrimental to the life or health of any individual is prohibited. They are not vague guidelines. They are enforceable standards that define what is acceptable near residential properties. The ordinance goes even further. It specifically lists certain noises that are automatically considered loud, disturbing, and unnecessary. One of them, loading and unloading operations. This is directly relevant to a gas station, which relies on fuel tankers, supply trucks, beverage deliveries, and garbage trucks, all of which involve idling engines, metal-on-metal impacts, and backup alarms. These are not occasional events. They are daily reoccurring operations that cannot be made quiet. The ordinance also addresses commercial noise near homes. It states that unreasonably loud or ruckus noise from the premise of any commercial establishment between 10 p.m. and 7 a.m., which is plainly audible a distance of 5 feet from any residential property, is prohibited. This one is the most important of the sections. A 24-hour gas station cannot comply with this requirement. Cars come and go at all hours, loud music from vehicles, gas pump audio, loud conversations, slamming doors, and nighttime deliveries. Homes in this area are as close as 700 feet away. The ordinance also recognizes the health impacts of noise. It states that loud noise, 1, interferes with the comfortable enjoyment of life and property, and 2, interferes with well-being, tranquility, and privacy of the home. These findings are not theoretical, they are factual. When you consider the ordinance as a whole, its purpose is unmistakable. It is designed to protect residential areas from exactly the type of continuous late night and early morning noise that a 24-hour gas station produces. And because the ordinance applies to all sound within the city limits, it cannot be waived or negotiated away. A special exception can be granted when a use is compatible with surrounding properties and does not adversely impact public health, safety, or welfare. The noise ordinance makes it clear that a 24-hour gas station at this location will violate the city's own standards for nighttime noise, loading operations, and residential protection. That means the use is incompatible by definition. For these reasons, and based on the city's own ordinance, I respectfully urge the council to deny the fuel component and deny Resolution 2025-17. I thank you for your time.
Thank you very much.
Thank you.
A little lower. Good evening, Honorable Mayor and council members. My name is Robin Pim Duranick, and I reside at 1284 Zesty Citrus Lane. My perspective this evening is rooted in a 40-year career in investigation and litigation management. My husband also served 25 years in the New Jersey State Police. So to us, public safety isn't a talking point, it's an imperative backed by decades of professional experience. I'm here to address the special exemption request for the proposed gas station. I want to highlight the 24-hour component of this plan and how it's fundamentally incapable with the safety of our rural residential community. The request for the 24-hour operation is not a minor detail. It's a major risk multiplier. The 2022 microspatial analysis published by BMC Public Health by Dr. Magdalena Cerda found that retailers operating 24 hours a day face more than double the odds, or 2.1 times the risk, of experiencing violent crimes compared to those with restricted hours. In addition, the FBI's most recent crime national report corroborates this. Specifically, gas stations and convenience stores accounted for 12% of all robberies in the United States. Nationally, they are among the third most frequent location for robberies, trailing only by streets and private homes. The research identifies a second critical danger that applies directly to this site. The Cerda study found that convenience stores see a 77% increase in violent crime odds when they are surrounded by a vacant land rather than established commercial land. As you know, the surrounding geographical and crossroads for this proposed gas station convenience store is currently a rural setting dominated by residential homes and mostly vacant lots. By placing a 24-hour business in this isolated environment, we're checking every box for what experts call a micro hotspot for crime. The proposal is to place a high-risk land use in the area that lacks the natural surveillance of a more developed commercial district. A special exemption is a privilege, not a right. It should only be granted if it does not adversely affect the public interest. The data is clear. The combination of the 24-hour operations and an isolated rural setting creates a substantially significant threat to our society and our safety. I urge this council to protect the character and the safety of our neighborhood by denying their request for the 24-hour operations. Let's prioritize safety of Minneola's residents over a developer's desire for a 24/7 gas convenience store. And I have this, the study and the data as well, if you'd like to see it.
City clerk, so she can add it to the city for record. Thank you very much.
Thank you.
Thank you.
Good evening, Nicole Marie Martin, 879 High Point Circle. Good evening. I am here tonight as a private resident with environmental concerns regarding the site conditions, and I am sharing these comments specifically in response to the environmental impacts and containment discussions that were brought up during tonight's discussion. Based on the St. Johns River Water Management District soil mapping presented, this site is made up mostly of very sandy soils, including LAB, LAD, and LAE soils surrounding a mapped BP pocket within the site area. What does that mean? In simple terms, these soils allow water to move through the ground very easily and very quickly instead of naturally keeping things contained in one place. So I understand the BP pocket has been presented as part of the containment approach. He said that that was the hydraulic pocket that would push everything up. However, my concern is that the surrounding sandy soils may not function as predictably as a more naturally contained soil environment. Water and anything carried with it can move through this type of landscape more easily because of the soil directly there. In context of a gas station with underground fuel tanks, that matters, because if there is ever a leak or failure over time, there is a greater potential for material to move beyond the immediate site through surrounding soils and toward nearby water features. Now, I understand with the modern underground storage systems, very fancy, they're designed with safeguards, and I do appreciate that. However, those systems still depend on the conditions that they are built in order to work. My concern is not whether the system is engineered well. My concern is how it functions long-term in a landscape where water naturally moves through the soil very easily. So the system may be engineered for containment, however, the site is not. Thank you.
Good evening. My name is William Graham. I'm a resident in Del Webb, 2602 Del Webb Drive. I'm a lifelong resident in the state of Florida, and I commend the City Council, both past and present, for the vision you all have had to make the Hills area a new gateway and a really special place for people to live. And I bring this to you really for the welfare and have a vision. In April of this year, April 17th, Forbes magazine published an article on 7-Eleven. 7-Eleven operates about 12,000 stores nationwide. In 2026, they're going to close about 5% of those stores. In fiscal year 24-25, they closed about 5% of those stores. 2 years' time, they've closed over 10% of the stores that they operate nationwide. And the reason I bring this up to you is twofold. It doesn't take a rocket scientist to know you put a gas station on a busy thoroughfare like Highway 50, US 27. The likelihood of them closing, having financial difficulties, slim to none. You put a gas station in a rural development area that has little traffic now, is going to have some growth. I get it, there's going to be growth. But the likelihood and probability of success is much less because of the location. One of the hardest redevelopment things that developers have to redevelop is an abandoned gas station. It's very expensive. They're eyesores. They sit and languish for long periods of time. How many of you have lived in this area and seen gas stations that got abandoned because a new Wawa went in and put the other two that were on the other corners out of business. How long does it take for those to get redeveloped? What is the vision when this one goes out? What's going to get redeveloped in there, and how long is it going to sit there and look? This is your gateway. You all have been charged and elected by the community to oversee and to look and to grow the development in a good way. This is not a wise development growth. It's a short-term fix. It's financially good for the developer. It's financially good for 7-Eleven now. But what do you do when they bail on you because there really isn't huge growth that they want to have? I ask that you deny this request for a zoning approval or zoning variance. Thank you.
Thank you.
Thank you.
Good evening. My name is Mark Johnson. I reside at 2766 Top Hill Court. I'm an attorney by trade, not near as eloquent as my friend Juan, who did such a great job. And so I will promise to be, which is not like attorneys, the shortest speaker you'll have tonight, and not necessarily add anything unique. But I just want to give you perspective. I've been in Orange County for 30-plus years, moved to Minneola about a year and a half ago, and part of the reason that I moved was for the vision of Minneola and who it was. And everyone I talked to as residents, how much they love being here. And I'm now, this is my third time sitting in this room. And it's just been very impressive to me to watch what has happened. I listened to the Planning Commission for hours and hours talking about that, voted unanimously, no, this is our recommendation, let's not do this. I came to a city council meeting, you guys were very gracious, listened to everyone's opinions, took in from the attorney from 7-Eleven, the cases, everything that was there, and you said, this is not what we want to do, 5-0. So then when I heard that, and I knew there was the option of mediated settlement, and there's option of litigation. So when I came, I was very interested to say, what is this mediated settlement? And although it's been a couple hours ago, Mr. Hernandez, you made such a great point. What is it that was any different from what we said before? Frankly, it's less. There's less things, less safeguards for the concerns that we have than when we first started. So I am thankful for what you guys have done, and I encourage you again to remind of what we've been through before this process, and truly think, what else is there now that would make any difference in the decision-making from what we unanimously agreed upon before. Thank you very much.
Thank you.
For all those that spoke tonight, also please sign in case the recording can't capture your information. Please make sure you sign in.
Hi, good evening. Good evening, Mayor Kelly, council members. My name is Lisa Flowers. I live at 2542 Del Webb Drive in Minneola. You've heard a lot tonight about the people who are against it. There's obviously, I would love to hear more, but we've been here 2 hours, so you've heard a lot tonight. I just wanted to kind of go over some key points that you've heard tonight, because there's been a ton of speakers. So you've heard about the aquifer refor. I don't think I have to repeat that. I think there's been eloquence way beyond what I could say about it, so I'm not going to repeat it, except to say that it is a fact that they haven't done the research. And now we have to figure out, can we actually say that this bill will not affect well water in the area? I don't think that anybody can say that today. So how do we vote yes? I agree with that. I think that's terrible. I also think that if Florida code has said that they feel that it's a high risk and a critical protection radius of 500 feet of a portable well for groundwater, then that is what we should be considering as well. And that there is somebody there. I don't care if it's one person and one family, it doesn't matter. I'm not talking for Del Webb, I'm talking as a community. We're here to support you and what Minneola was supposed to be. The fuel systems, while I work in IT, yeah, there's great systems in place. I will tell you that as many times as the system has failed in my companies, as a human being has to respond. How fast is it going to take? The systems fail. I've had my own backups fail on me, and I've had to have a security guard go in and type things for me because I didn't have anything in place the right way, or the system in place didn't work. So I understand that there's things that will prevent fuel spills, but they're not foolproof, and that is also a concern. Again, there's people here. The second, we talked about the cyclist, the safety. I do feel that they talked about changing lanes and doing things. I don't know if you've seen it, but already we have donuts being happening in front of Del Webb Drive. I mean, you can go up there and drive it and you will see it. Today, the noise, we can hear the noise at night from the freeway. I chose to live there, I fully accept that, but I don't really hear it that much during the day because, life is going on. But at night, you can hear all those tractor trailers out there because that's when they drive. And that's when they get fuel. And that's when they'll make pit stops. And that's when people with smaller vans, like Amazon, will also be doing those things. And if they can stop at that fuel station, it's the closest one. It will be, I think, the closest one to the interstate. The children and cyclists, we are going to have Lennar all around Del Webb. There'll be a lot more kids and a lot more people walking. This gas station is going to cause concerns for that. I think that is fairly obvious and a safety issue. And when we talked about environmental, traffic studies, access, environmental to me isn't just about the aquifer, it's about the environment I'm living in. This community, and the reason I came to live in Minneola was because it was not going to be a big box store. It was going to be the small community that I grew up in New York, that we had a voice and that you give us that voice. So I respectfully say that at this time, you have heard a lot from the community, that a 24-hour gas station entrance to the space is not the right location. I think that the evidence presented tonight shows that the applicant has not met their burden. They did not come prepared and required for a special exception. I will say that as a community, we gave you facts. We gave you lots of papers. We told you things. We did our research. You ask us a question, we will be able to answer it tonight. Every meeting I've been at, they have not been able to answer a single question clearly, identifiably, where I could say, oh, I get it. I support it. Nobody in the room, I don't think anybody can say that. And again, they've come again without having everything. So maybe when they come up for the rebuttal, they'll have more information for us. We'd love to hear it. But I respectfully ask that the council deny the mediation agreement and the resolution of 2025-17. Thank you very much.
Thank you.
Is there anybody else in the audience, public, who want to speak before Santara speaks? Okay, at this time I'm closing public comment. Thank you very much, and thank you for being professional and respectful. It's much appreciated.
Thank you, Mr. Mayor. Just one statement. Earlier today, our counsel, Brent Spain, emailed a letter to the city clerk and to Mr. Gerken, along with a copy of Sean Flynn's professional background, and we request that copies of those be put in the record tonight of tonight's hearing. And we also request our slide presentation be part of the record for tonight's hearing for both of those, so that, along with the city's complete development files. A lot of things said, but a lot of things with no substance and only half-truths. Somebody said that there was 5 leaks at 7-Elevens. I'm not sure what that means. I mean, every incident in a gas station or any Wawa or any of them is recorded. If there's a 5-gallon can and somebody doesn't overfills it and it spills on the ground or on the concrete, it's recorded. If somebody pulls a pump off, it's recorded. So we're not talking, all those comments scare people, but we're not talking about leaks in tanks. So none of those incidents we know were leaks in tanks. By the way, the answer is diesel, yes, ethanol, no. Another thing that was said was inferred that Sean Parks is against this. That's all hearsay. He's not here. I can't imagine Commissioner Parks commenting on a local application of such as this. So I disregard that, and I intend to find out if that's true or not true, but I don't believe it's true. All the environmental stuff about sensitive areas and all that kind of stuff, I mean, the aquifer is 125 feet down. Let me just bring Sean back up to make just a couple comments regarding that brief.
Out of due respect, he has the right to do that, so please.
I just want to say that I based my presentation on the potential impact to the Florida aquifer on science and not emotion and speculation. The Florida aquifer, the depth of water is greater than 40 feet. The top of the confining unit is 95 feet below land surface. And the top of the Florida aquifer is between 125 and 135 feet with an upward potentiometric surface. So it would have to be one heck of a release, probably an entire USD system, 15,000 gallons, to even have a chance of getting down to the Hawthorne Formation. So what would happen if they had some catastrophic event, I'll just be a few seconds, is they would have a vac truck out there that would remove as much product as they could from the tank so it didn't get into the environment. That's all I got.
I do have a question, and it's just, I'm trying to grasp something. So how big is one of these tanks?
I
15,000?
think this one's gonna be a 20.
Okay. How big is a fuel tanker?
6 gallons?
No, a
15.
fuel tanker, a semi. Does anybody? About 5. Same thing, milk, gas, got it. That says about 5,000. Between 5 and 10,000 gallons, let's just say,
Okay, yeah, between 5 and 10, yeah.
I'm just trying to put perspective, how much fuel is in there compared to if, okay.
In answer to that too, don't forget there's a containment area all the way around the site that if there's a spill on the concrete, it's generally totally contained on the site. There was one other comment on traffic regarding access with our neighbor. The county's policy is if you're first, you can access and you put it on your property line basically, and you provide an easement to your neighbor. So everybody uses, because they only want one access, so everybody uses that access. Well, we're first, and that's what the county has told us, and that's the way it'll process. We will be required to provide them an easement to access the access to 561A that we built. So that, I think, covers what we want to cover. Is there any questions to me?
Council at this time. Anyone?
No questions. Thank you, Richard.
Joe,
Okay.
Mr. Saunders?
No questions.
Ms. Lynn?
No questions.
Ma'am?
None, thank you.
Thank you for your time.
Thank you very much. With that said, I'll bring it back to council. And how do we handle this, Scott? Can you please give me some instructions?
Well, it's your time to deliberate. If there's any more facts or anything you need, you certainly can ask at that time. Otherwise, you just need a motion and vote on first on the mediated settlement agreement. If that's defeated, you wouldn't even move on to the second. If you pass the first, you then can vote on the actual resolution, the special exception.
So just want
And by the way, the letter that was mentioned is at each of your seats, so it has been provided.
So a lot has been said about development in the future of Minneola and the vision that we have. As we all know, this is already zoned for commercial. So it is coming, and yes, keeping Minneola mini is a cute slogan, but unfortunately, that's not in the cards of what's going to happen. What we do need to work on is smart development and smart growth and what's needed by the community and for the community. If we try to stop development, it's not going to be a good thing for any of us or for the city. However, if we do work together and we provide insights, we provide ideas, and we provide items that the developers, not just specifically this one, but all within Minneola, are able to use, then we can have a harmonious relationship with them in order to get what Minneola wants and what we need as residents. Therefore, unless anybody has any more comments?
I have nothing. Since you have anything?
Nope.
Any final comments?
Nope.
Any final comments? Joe, anything final?
So I would like to make a motion to deny item number 8, mediated settlement agreement for Gen Florida LLC.
Okay.
And I will second.
Okay, so before we go through this, because
We did this before.
I just want to make sure Scott cringes on this one. We understand what they're doing, but we just want to make sure that everybody votes correctly, because it goes one way and they vote the wrong way. So, Scott, there is cards on the table. Can you please explain to us how this
Yes,
works?
I'm sure what you're speaking is, I always hate negative motions, but they are legal. But
And
just-
that's fine, but I just want to
so-
make sure that I've
You're-
been up here a long time, and I have voted the wrong way on them,
Yes.
thinking I was going one way and like turn left, left blinker, turn right, that type of thing. So please.
Well, the motion is to deny and has a second, and so voting yes denies the mediated settlement agreement and stops the proceedings. You don't go on to number 9 then.
Okay, so If we vote yay.
Yes is a
denial.
no to
It's a
the
denial,
settlement
correct.
agreement.
Okay.
Denial.
Okay, I just want to make sure. Okay, as we discussed in our last meeting, this will be a roll call vote. It will be starting with Mr. Hernandez. Move seat 4, seat 3.
Wait.
It will start with Joe. We'll start with Joe, seat 5. Move to Mr. Hernandez, Ms. Flynn, the vice mayor, and then I will have the final vote. So, Mr.
I don't have a problem with that, but why do it different than we always do it? Would you start at seat 1 and move to seat 1 and
Because
5?
that's just how we asked last time how we would do it, and you volunteered to go first.
Aye.
So what is it? Aye?
Yep.
Okay.
Aye.
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 The chair votes aye. So it's denied.
Ayes, yeses, so 5, so the mediated settlement agreement is defeated.
Yes.
Yes.
Mr. Mayor, I would like to, do we have to go to item number 9, Scott? or is
No,
that
as
automatic?
mentioned,
No,
by
it's-
defeating that, we won't consider item
We
9.
take a short recess, please.
So moved?
Yes. Second?
All in favor, say aye.
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 RCP.
What?
When she's on, she's on.
Joe Saunders, please report to the top. Joe Saunders. Please report to your seats.
What?
Be here when I get here.
There you go.
Call city council meeting back to order, please. Preliminary subdivision plat, Camp Lake Industrial. Luckily, you get paid by the hour.
This is a quasi judicial. Can we get you, Eric, and if there's anybody else that wants to speak on this, if you could, you swear from any testimony you give this evening is the truth, the whole truth, and nothing but the truth. If so, please say I do.
I do.
Thank you.
All right. Thank you, Mayor and Council. For the record, Eric Roche with Inspired Placemaking here in my capacity as a contract planner to the city. This is item number 10, which is the Camp Lake Industrial PSP. We'll run through just quickly the location and history of the project. I'll outline the applicant's request, and then I'll wrap up with a quick summary. So this one's located west of North Hancock Road and Florida's Turnpike. It's north of Citrus Grove Road. It's 164 acres in size, and it's zoned PUD. This was part of the original Hills of Minneola PUD, and the access to the site comes from Turkey Farm Road. Just a bit of history on the site. This PD was originally approved back in 2006. There was a large amendment in 2019 that designated this area as industrial and research park. You can see the subject property outlined in the red box on the screen. That's Camp Lake in the middle. The PD is approved for 1.4 million square feet of industrial uses. City Council approved the site plan for the project back in December of 2024. And that site plan included about 378,000 square feet of warehouse uses. We came back to City Council with some variances in November of 25, which were approved. Those were the variances for the flat roofs. And I know we've had a lot of discussions at this board about the flat roofs. And you'll note that Phase 1A is currently under construction. That's the construction you see out there at the intersection of the Turnpike and Hancock, with buildings now going vertical. So here tonight, we're not really discussing the site plan or the entitlements for the property. All of those things have been resolved. We're simply here discussing a subdivision of the property. So the applicants applied to subdivide the property into 3 lots, which are shown on the screen. The first lot is what's currently under construction, shown on the top of the page, with access from Turkey Farm Road. And then moving north, there will be 2 additional lots for future development to accommodate the rest of the project. So the applicant can speak to their ownership structure and the entities that are proposed to own these lots. But otherwise, it's all generally private infrastructure north of the cul-de-sac that you'll see, the utilities through easements and such.
I do have a question, and it's not really, I'm fine with the subdividing, but I just want a clarification. I drove the property last Saturday prior to the big burn. Can you go back to the map of this one piece, another one? Looking at this map, and Scott, clarify, please. The road, I know that we're trying to purchase that one triangle. Is that road 100% on the city property, or is that shared between Lot 3 and the Monica property? Do you know? Because here it looks like it's...
That road at the triangle is, my understanding, is fully on the Monica property.
Like kinks upward onto the Monica property.
Okay. And I won't be here, but just for when we drove it, my wife and I were talking, it seems to be a dumping ground. Since if at any point in time the city does acquire that property, they might want to consider putting some type of, just a bar gate across it to stop people from going back there and dropping it, because it's pretty nasty back there with tires and mattresses and all that. So I thought it was the applicant had 3, and we're gonna have to try to work a deal with, do you have it? But if it's all ours, then he doesn't. And there's no reason for us to well, ask the applicant, if that road was to get closed, that doesn't impact your project at all, correct? Or you can ask.
Defer to the applicant.
You can come up, please. I just want to make sure while you're here, because it would be Lot 3. I know y'all are changing y'all structures, but I didn't know if that road was to get blocked.
Yeah, good evening, Kevin Castile, 2235 Roxburgh Drive in Roswell, Georgia. You are correct. So the third lot that we're trying to create, currently we do not own that. It's still owned by the previous landowners. The intent is for us to purchase that in the near future. In the event we do, we don't have any issue with, at least prior to us developing that lot, that road being gated. It's just means for trespassing currently, and people riding on our property and dumping and things of that nature, so.
Yeah, okay, I was just curious. So that's just a future thought on the tickler for future as we go down. But thank you. Okay, continue on. So this is just basically take one lot into 3?
That's correct.
Yep.
I'm
So-
fine with that. Is there anybody, any questions? Anybody in the audience have any questions, concerns? This is a lot split, 1 per 3, and once they do this, can they do it again? We have that part of lot splits and meets and bounds and all that. So this is a one-time.
Yeah, this is actually a formal subdivision, so they'll still have to go through the plat process.
Yeah.
So they would have to, if they wanted to split further, they would have to.
And have to go through the same
go through the
process again.
process and
Okay,
amend it.
that's fine. Cool, I'm fine with it. Joe, do you have any questions, concerns?
I do.
Okay.
I went up with Mark Johnson yesterday and looked at the first building that's going vertical.
You might want to step up for this. On the plus side, he hadn't pulled out a list yet, but it's probably in his head.
And the second slab has been poured, and looks like it'll be soon that they'll be putting that building up as well. And when we approved this, I had a concern that the looks from the highway would be detrimental to the city of Minneola. In the renderings, looking at the renderings and during the process of looking at the documentation, I thought there was going to be like 30 overhead doors in a row on the highway. I think you assured me that there was going to be a berm, that you wouldn't see the doors, and there's trees in the berm. But it appears to me that the second building is going to be in a void where there's no berm and there's no trees. But I'll tell you, I was dumbfounded by, I didn't see 30 doors in a row. There are 80 overhead doors, all in a row along the highway. And if you could see it from the highway, it's going to look ugly as far as I'm concerned. I would have much rather they turned the building around, and they had reasons for not wanting to do that, and I respect that. But 80 overhead doors in a row, tractor trailers lined up to it. The first building going up is hard to see past the berm, but you can see it from the interchange. You look down the front of the back of that building facing the turnpike, it's going to look horrible. It would be nice if we could camouflage it somehow with more trees and more berm, and I'm not suggesting that we make that requirement, but I'm just telling you, from my point of view, it looks horrible. 80 doors in a row.
When he says you can see it, he means the doors, not the building. He's talking about the doors.
In fact, it looks like each unit has 2 overhead doors, and the last unit has a big overhead door, like twice the size of the typical door. When you get to the end of the second building, the third building, which is not under construction or in the plan yet, is going to turn 90 degrees, I think, from the 2 buildings that are under construction now. And then there's going to be a total of 7 buildings. Am I right or wrong there?
Correct, that's what's currently proposed.
Total of 7 buildings. The other buildings, I don't think are going to face the highway, and I'm less concerned about those, but If I was coming down the highway and I was looking at all those doors with tractor trailers stuck outside of them, I wouldn't think Minneola was such a great place. That's my honest opinion. Prove me wrong.
Thank you.
Yeah, I would just, all I would ask is to allow us to, I would agree that during construction, it's definitely not a pretty sight. It's a big concrete wall at the moment. A lot of dust and dirt. We try to keep the dust down, obviously, as best we can with water trucks, but there's a lot of more landscaping that will go in as we finish construction of the project. The berms are not at final stage yet. There's a lot more glass and painting and reveals and things like that on the building, signage. So I understand your concerns today are still the same and maybe emphasized even more from when we originally spoke. So just want to clarify, we're a long ways from being completed, but happy to discuss those concerns further as we get to more of the finished product. And if there's additional things we can do, we're happy to talk about that to see what that could be.
Well, I hope the berm goes all the way the length of the building. Right now, it doesn't. It looked like it would take a lot of fill to build the berm there.
But the berm won't go completely to the end of building A.
It does?
But there is a lot additional landscaping and things that will go in there.
Okay, well, be nice if it does, because right now you can look straight past the building out to the turnpike.
Understood. And part of the thought, understanding it's the front door to the city, and always wanted to take that into consideration for sure. Part of the thought too is the future development of the land next to us that we do not own, the two parcels along Turkey Farm Road. I think there's plans for that to all be developed and for a mix of uses, and trying to make sure that we're being a friendly neighbor to those landowners as well, so that can all be developed cohesively.
I know a woman that lives in the reserves. The back of her house faces the interchange, and she can see that building. She's already complained that it looks really bad. She never thought Minneola would do that to her. That's a quote.
Understood. And I agree, during construction, it looks unfinished.
Okay, enough said.
Thank you very much. Any other questions, concerns? Just need a motion for approval?
Oh, I just had one quick one. On our agenda summary, there's quite a few staff recommendations. I'm sure you're aware of those. The retaining wall, security and facility requirements. You know about all those. Are you good with that, all the recommendations? Maintenance and cleanliness, no outside vending machines, et cetera.
I'm not sure. Those were recommendations from staff from last night for my project?
It's on my agenda.
I believe there were some,
Yeah, staff recommends approval of the following conditions at the time of construction plans. The slope grade changes, retaining walls for proposed Turkey Farm Road must be evaluated to ensure adjacent properties can access the road, which I think you commented that when you were saying being a good neighbor.
I'm sorry, I see it up there now. Okay, yes, so, correct. All the other properties, adjacent properties, for the road that we're improving and maintaining, the adjacent property owners have the right to access and utilize that road as well. It will be our responsibility, as I just stated, to maintain it, and we are constructing it in a way that's already been reviewed and approved by city staff.
Thank you.
Thank you, Ms. Flynn.
So if you wish to approve it with the staff conditions, that'd be appropriate.
Are you okay with staff conditions? He's rereading it.
Yeah.
I guess a point of clarification. If our design, I'm just using this as an example, let's say that we end up submitting for a change to the design from what's currently been approved. So let's say removal of guardrail, because the slopes become less significant, we have less incline, et cetera.
You don't need a guardrail, you don't need a guardrail.
Okay, this wouldn't require us to come back through public process for anything that the city is able to, at staff
You're
level.
concerned that we say you have to put a guardrail in, and then all of a sudden you design it in such a way you don't need a guardrail, and somebody comes back and says, where's the guardrail?
Correct.
Yeah.
This is an
Only if it's
engineer,
necessary.
staff level approval. Okay, yeah, then yes.
Okay. Anything else?
There's already a road agreement that frankly addresses most, if not all of that anyway. So,
It does, and the
yeah.
permit today actually requires a guardrail.
Right.
But in the future, if it didn't, for whatever reason, whether it was interconnection with the neighboring parcels, redesign of the road that the staff approved, I just wanted to make sure that was clear.
Anything else? I just want to comment, I think you have, the project's big. I think I see a lot of these buildings up and down the turnpike. There's one at Orange Western Trail that's kind of big. They do look nice. I mean, if it starts looking trashy, then you're trying to get higher end attendance. It's about driving your business. You know, people aren't going to want to be there, but I think you've been a good partner for the city. I appreciate y'all coming here and actually going vertical and giving opportunity. I know there's been a lot of discussion. Do some things on the other side of the county dealing with Lake County, and they're very excited to have this here as an opportunity for businesses to come here. So all your support for council, myself, the city is much appreciated.
Thank you. Glad to be here.
And Mayor, just if I could, forgot my last slide. This did go to P&Z last night. It was recommended for approval unanimously. They just requested the applicant evaluate opportunities for natural buffering, coordinate with adjacent properties, and then adhere to the staff recommendations. So they were supportive. I didn't want to downplay their involvement in this project. We had a good conversation last night, so thank you.
We got you, Nicole. So, yeah, with that said, bring it back to council for approval.
So moved.
Second.
I'll second.
All in favor say aye.
Aye.
So,
That was with the staff recommendation.
With staff
yeah.
recommendations.
Safe travels back to
Georgia.
Georgia. Hopefully we're planning Flying Spirit.
Damn you.
Ooh, too soon.
Too soon.
Okay, Saxon Industrial Park. Let's turn back time. This is when I first came on council. It's been a long time with old school talk about the industrial park and a racetrack gas station down there.
Yeah, I understand this one has quite a bit of history.
Yeah, you were
predates
like in
me.
high school.
Yeah, predates me. By a bit. I'm flattered, thank you. Eric Rosh, for the record, Eric Rosh with Inspire, here in my capacity as a contract planner. This is item 11, Saxon Industrial Variances. Run through the location, the request, and then I'll run through the variance criteria before wrapping up with a summary. So this one's north of County Road 561 and east of Causey Road. It's zoned I-1, has an industrial future land use, so it's set up for future industrial uses. And there's a pending site plan out there for about 17,000 square feet of industrial. And back in 2018, it was granted a few variances. They had a reduced front setback from 30 feet to 25 feet, and that went from a type D to a type C. So the differentiation between D and C is the amount of plant material that has to go in the buffer area. Same with the side setback. They were granted a reduction from 30 feet to 20 feet. And just for some context, unincorporated Lake counties immediately to the east and to the south. And then to the immediate west, there is a piece of property that's zoned B1, it's owned by Racetrack, as referenced by the mayor.
Yeah, and that one still has fuel on it too. It still has, they can put fuel there if they want. Yeah, I'm just saying it could.
It could, well, the broker says Racetrack aims to sell it, and they have a restriction against.
Well, because it takes away from their competition up here. I get it, but it does have it on there. So it was.
Still own it.
Suffice it to say, they received some setback and buffering relief back in 2018. The project never moved forward. They came back in to restart the site plan process recently. And Lake County is requesting 17 feet of additional right-of-way for future improvements to County Road 561. And then there's a request from city staff for a utility easement along the frontage of this property for 20 feet for future pipes. So if you look at the overall site plan, the space has to come from somewhere. You've got a pond in the back, you've got the building footprint itself, you've got a single drive aisle and 2 rows of parking stalls, and then there's environmentally sensitive property on the back. That's a wetland in the rear of the site. So rather than encroaching into the wetland, you can't reduce the pond size. They've elected to request a variance to allow for some additional relief on buffering and setbacks. So the requests are from section 110.3B and 110.6 of the Land Development Code. So they want a 11-foot front setback and removing any trees in that buffer area. Just go with shrubs because there's impacts to the potential utility pipes that will be installed within the utility easement to the city. And then they want to allow a 6-foot encroachment on the southwest landscape buffer. You can see it on the right side of the screen, the small little triangle, that's the 6-foot encroachment. And they're proffering some additional buffering. So they don't have the luxury of turning the building to stay out of that setback because just the way the road lines up in front of the property. So that's their justification for that. There's 6 criteria in the code. We've gone through these a number of times. Number 1 is no reduction of property value. Number 2 is the granting has to be in benefit to the public interest. Number 3 is the denial would result in an unnecessary hardship to the applicant. Number 4, it can't be contrary to the spirit of the code. 5 and 6 are regarding hardships. 5 is financial hardships, and 6 is physical hardships. And I'll step through those one by one. So in terms of the property value itself, we evaluated the southwest buffer encroachment as it relates to the property of the west, and they're proposing some offsetting landscaping in lieu of that 6-foot encroachment. And again, they're going to have shrubs and other plantings in the front to soften the appearance from 561. So we felt like there wasn't a real reduction in property values for the adjacent owners. The second benefit to the public interest, we noted that there's a necessary provision of infrastructure here, particularly the right-of-way acquisition for the 561 expansion and the utility infrastructure, which is going to eat up 37 feet of the frontage of this site. So we felt like that was a pretty good justification to the public interest that will be public infrastructure. And additionally, it'll allow them to maintain good site access and a drive aisle and adequate parking for the site, so they won't have to lose a row of parking to park their site. And again, the wetlands on the north of the property, by taking the property off the front, protects the wetlands in the back. The unnecessary hardship language. I mentioned the wetland on the property, and this is a way to preserve their development rights without disturbing the wetland. And then again, back to the right-of-way that's been required by the county. They would have to lose parking spaces, or they would have to lose a building footprint, which could be a hardship. The spirit of the Land Development Code is number 4, and it references the appearance, function, and livability of the city. I think this will allow them to use their property for their intended use, which is industrial, and it allows for that 561 corridor to continue to grow, consistent with the county's vision as outlined in the comp plan. And additionally, there are some provisions in the code that allow council to waive required landscaping if they're unreasonable due to site restrictions. So that's another benefit to the applicant. They haven't claimed a financial disadvantage as associated with this request. It's just to allow the site to be developed with the industrial uses that were always contemplated for it and provide the required parking. And finally, they haven't proposed or indicated they have any physical hardship, so that's not really applicable. So our recommendation is to make a finding of consistency with those criteria and approve the 2 variances. This did go to P&Z. They voted 4-0 to approve with conditions. to preserve the function of the buffer, prioritize Florida native species in terms of the plantings, ensure placement protects adjacent uses, and avoid long-term weakening of the buffer's intent. So with that, I'll stand for any questions, and I believe we have the applicant here as well. Thank you.
I'm good with it as it reads. Thank you for the land on 561. Not that you had a choice. So thank you for that. This is gonna be one of those weird projects where when it goes in, it's gonna have a sidewalk to nowhere. Okay. So. Okay, yeah, I'm fine. Is there any questions, concerns? Anybody in the audience want to speak on this? Joe, you got anything?
No.
Nope, I'm good.
Okay, with that said, can I get a motion?
I'll make a motion to approve Resolution 2026-03, Saxon Industrial Park variance.
Okay, can I get a second?
I'll second.
First, second, all in favor, say aye.
Aye.
All opposed, motion carries. Okay, the next one is the coveted golf cart. This is first reading. We're just gonna read this, and really no, we don't have discussion tonight, or we can push the first reading to a future meeting. It's getting late.
That's your call.
It's up to you.
The only thing we have to do is read it.
You
Or we can push the
Let's
first
read
reading.
it, no discussion,
read it.
and then we'll come back for second reading. We'll have discussion then.
Actually, having said that, I don't have the title in front of me.
Thank you, Eric.
Thanks.
Have a good night.
If you've got it, I can get it in, hold on. I move slowly. Got it. Nothing wrong with that. Thank you. All right, hold on, I got it. Oops. Ordinance 2026-07 on first reading, an ordinance of the City Council of the City of Minneola, Florida, amending Chapter 44 of the General Ordinances of the City of Minneola relating to motor vehicles and traffic, amending Article 1, amending Section 44-5, definitions, creating 44-6, golf cart and low-speed vehicle operation, providing for regulation of golf carts on public streets, private streets within homeowners associations, and roadways within community development districts, providing for signage requirements, providing for inclusion in the Code of Ordinances, providing for conflict, providing for severability, providing for an effective date.
Okay. With that said, that's first reading. It will come back for second reading. Final public comment at this time? I forgot item 7, sorry.
Oh, yeah.
Be honest.
What happened?
You wanted item 7
wanted
called
item
out by-
7 moved.
The pier.
Sorry, Jennifer.
Sorry, Jennifer. Oh, there we go, item 7.
Okay, item 7. Contract pier construction. I'm fine with it as it just needs to go. Do you have any comments, Debbie, you'd like to make?
Honestly, this is my opinion only. I think we have a lot of projects, like Eric does every meeting that we have. I just think this is a $200,000 expense that we don't need to do at this time. We've got lights, sidewalks that need repaired, water treatment plant. I just don't think it's the right time.
Okay.
You have your opinion. Perfect.
Thank you for your. Can I get a motion to approve, or keeping with the theme of the night? or
So
deny?
moved.
I'll second.
To approve?
Yes.
Okay. Got a motion to approve?
I'll second.
All in favor say aye.
Aye.
All opposed?
Nay.
Okay, motion carries. Okay, Jennifer.
Sorry, Jennifer.
Jennifer Morse, 1064 Golden Don Loop. To Mr. Saunders' discussion about that eyesore, I'm not so concerned about the Turnpike View because those aren't Minneola residents. I'm concerned about our eyesore that we're looking at Hancock and Citrus. So I really want, I don't care, I do care, but I really want us to pressure them to go above and beyond what we may have approved in the PUD for whatever that corner is going to look like and the trees. Because people are upset and kind of, I won't even say like I'm depressed about it. Like, I didn't even know that I missed it. I didn't know that it was going to be that close to us. I thought it was going to be more off the turnpike and we weren't going to see it. So when I saw it, I was like, wow, that kind of sucks. So, sorry, but
And
a
the
lot of
pictures
people.
did no justice either. you
Yeah,
know.
yeah. So, I just hope that the council will, really push for something that would beautify that area. I know they're in construction right now, but, as much pressure we can do for them, that would be great. I did see a water conservation. I have to say this, because I even posted it online, to say that we need to reduce our showers is kind of laughable when we're watering our weed-ridden grass with the same water that I shower with. So if we can prioritize getting reclaimed water system online and not 2 years out again, because it was 2 years out 2 years ago, that would be wonderful. Thank you.
Thank you.
Thank you, as always.
Dave Yeager, 2750 Purple Meadow Court. How about that flagpole? I was there from the start to the finish. I wouldn't leave, and it looks really nice. It needs lights, of course, so we can put the flag up. And then how about that fire we had next to our property? It freaked my wife out. I wasn't around, and she thought the place was burning down, and it was close, except my property has a great berm. But your property is a little smoky. And then we went to dinner at 5 o'clock and saw more fire engines because it lit up again. But and the men's room counters were really nice. Very nice. But the ledges that I look at are very ugly. And the door lock is torn off. So it's all right. You did a great job. The cars are beautiful, though. So if you don't look up, you're fine. If you look down, it's... Yeah. But that piece of marble on...
They're not
the
coming
window-
from the same place that the fire department doors were coming from, are they? Okay, just
we
want to
don't-
make sure that...
But anyway, so the flagpole's incredible, and I can't wait till the flag goes up and the light goes on, and we'll know where Minneola is. Thank you.
Anyone else? Mark?
As quick as I can, the graffiti under the tunnel, we've had a couple of companies tell us they can't remove it without damaging the blocks. We're working on another company to try to get them out there. So we are working on it. It's not done yet, but we're just trying to find a company that can get in there and get it done. The location and the access to vehicles is a little challenging for some of the companies as well with their equipment. The Scenic View Swell project's about 50% complete. The Trailhead Park restrooms, the building's been demolished. The contractor submitted to the building department the final design on April the 30th. And they ordered the trusses, and they're working on the slab this week. They're out there grinding off the old tile set off the concrete. They're out there today doing that. They believe, we believe, I'll put it that way, we believe they'll be done within 110 days or so of today, with the whole bathroom. As far as the groundbreaking for Trailhead Park project, we were looking at May 15th at 5, it's on a Friday, or May 16th on a Saturday, whichever time the council prefers. If those times don't work, we'll go back and look at a different time.
May 16th.
May 16th on a Saturday?
That's my vote, yes.
What time is good for everybody?
4 a.m.
Okay, all right.
No, I think 10, 11. It's a reasonable morning time.
Everyone make May 16th at 10?
10?
Be earlier. The sun comes out at 11. The sun's out. Yep. The nugget I got to worry about.
There's trees there. We'll be fine. I'll get you a hard hat.
There is a tree. It's just really big.
I'll get you an hard hat. Don't worry. They're not going to be fine. 10 o'clock. 10 o'clock? 10?
10 o'clock, May 16th.
Everybody go with that date?
Yeah, figure it out.
Also, a recent issue, the Hills, The company they use changed out their streetlights with LEDs. I'm getting a lot of complaints from residents about that, so I'm meeting with the power company representatives soon to kind of talk through some ideas and see what we can do to help resolve it. But it is very bright, and we're getting quite a few complaints about it.
Okay.
That's it.
Is that a bear joke? That was a good bear joke.
Okay, anything for the city manager?
No. Thank you.
No, at this time.
Bear Watch 2026 was great, Mark, thank you. Did we ever, yeah. Thank you, Nathan, for being Bear Watch man, so Yogi's assistant, appreciate that.
You
Oh,
should
yeah.
have told him there was no soliciting.
That's what I told him. Yogi and
He
Boo
was using
Boo.
the sidewalk.
Yeah,
Yeah,
for those
he
who don't know,
was
there
using
was
the
an
sidewalk. That was very
approximately
respectful.
400-pound bear that walked through our neighborhood. Big Mama Jamba.
Yeah.
Big bear, yeah.
He was looking for Grizzly Adams
Now,
back
is he
there.
what?
He's looking.
I didn't hear what.
He was looking for Grizzly Adams back there.
Grizzly Adams did have a beard.
Before you come.
Yeah, no, but that's
You missed trash
Happy
day by
Gilmore
a day,
joke.
though. If you'd have been there a day earlier.
Yeah.
that would have been bad.
But he went through like 8 fences, from what I read. Mm-hmm.
Nice. Dude, did they ever find out where he is?
No, he would have gone right up.
So,
Oh, I thought you meant, like you said, trees in the surrounding area, not our neighborhood. Oh,
is that
Yep.
him? Okay. Anything for the city
No.
manager?
No, I'm
Anything
good.
for the city manager?
No.
Scott?
Nothing this evening.
Anything for Scott?
Thank you for the phone call. Appreciate your time. And that'll be all for Scott.
Thank you.
Thank you for all your time this week as well. Thank you. And last week.
thank you, Scott. Do you have anything for Scott?
No.
No.
Okay, I have nothing. Thank you, Scott, for everything.
You're welcome.
Okay, I have a suggestion. Since Debbie stepped down from being a liaison for P&Z, I would like to make a recommendation to have the chairperson, Denise Caldrone, to be at upcoming meetings. Whenever something is on P&Z coming in front of council, I would appreciate it if you can be there, so that if we have any questions, we can go directly to you. I'm asking for the chair, has nothing to do with anybody else on P&Z. It's just because you are chair, I feel that you would be the proper person to ask to do that. That's just my recommendation, and I don't know if we need to make a vote on that, or just an agreement and move from there.
You're the mayor. At that point in time,
I will be,
you will be the mayor,
right,
and you.
but I want to get everyone's input.
No.
So does that mean that you will get rid of the liaison and the chair will come to the meetings?
Well, for right now, I think that's the best thing to do after we go ahead, after elections happen, and see who is up here and who is not, and then take it from there. But again, I'm only one. If you have any suggestions, Debbie, then go right ahead and make them.
Well, you're the alternate.
Right, but I was told not to step in at last night's meeting
Oh, okay. I didn't know.
because I will be stepping into the mayor's position.
Okay. I like the idea of the chair being at the meeting.
Yeah, I originally wanted someone else, but I think the chair having the role that speaks on the behalf of P&Z, I think is a good idea. Yeah.
I do too.
Is that for indefinite or just until?
Take it day by day. We'll take it to the election.
Sure.
Let's test the waters a little bit.
10-4. I
think
agree.
there's
Joe?
Sorry, Denny.
Go ahead.
I got nothing to say. It's fine with me. Have at it, Denise.
It was it was a long time ago, and this will be my last meeting, but when I became mayor, I think one of the first things I did, I changed a lot of things. Some things, we no longer had assigned parking spaces. That was a big one.
Yeah.
The day and these are things as the mayor that you can control. I went away, I went to a moment of silence. I know you had your, and I was thinking about this, you had your you had your National Prayer Day. If you want to bring invocation back, then you can do that and have somebody come and say a prayer like other municipalities do. It is your meeting to do what you want. If you want seating, I don't think there's any rule that says you can't. If you want to sit in the middle and have one here, nothing says that you can't go boom. You can't go, Debbie move down and go two, then Eric, then you move down.
Right.
You can move your seating changes. There's a lot you can do. The agenda is going to be yours, so anything that comes on probably needs to get your approval. I think over the years, I've let staff have kind of liaison on it, like they kind of added things and not added things, but you own the agenda. If you don't want something on the agenda, you can have it removed. So pretty much any requests need to go through you. I think you'll do a great job while you're here. Maybe you like to do it longer, I don't know, but I wish you luck, and those are the rules of how you want to run the city.
Right.
You're it for the city.
I appreciate that. It's just that I felt,
I know,
since there was no one there last night, that come June's meeting, I believe we need to have, from here on out, have Ms. Denise Caldrone just be
And
present at our city council meetings in case we have any questions.
I mean, there's a point here, I remember when I first started, we would have P&Z, but we had everybody up at dais. We had the fire chief up here, we had the sheriff's department here.
Absolutely, yeah.
So if you want to put the P&Z liaison down there at the chair and have her sit there, then you can do that.
Right.
The dais is yours to design. It's
Right.
your city. You run it the way you want to.
I just.
Check with Scott first.
I'm just saying from the past, Nathan would be in the audience, and Nathan would come up, and he would have a lot of input, and it was great input. So that's kind of like what I'm looking at to kind of implement again, but through the chair.
If that's how you want to run it, then have it.
Okay. That's, again, a suggestion, and
Shall we put that as a consensus of council, as
Yes.
approval? Trying that till the election. Obviously, if the chair can't make it for a meeting, she can always designate someone
right,
to come. so,
absolutely.
Call it punting.
Yeah, it happens. yeah.
Thank you.
Anything else?
That is, one more last thing. I do want to clarify something. Last meeting, I had mentioned and you made a very good point with your facial expression, that's what caught me, in regards to the pier taking 10 months to do. I have been corrected, and they had mentioned that once permitting, first of all, the contract has to go through first.
Yeah, I get it.
But after permitting gets done, then it's about 4 months, maybe top 6 months of actual production time.
That's fine. It's just,
So-
but the permitting I've heard is going to be
Is the crucial.
Is the big piece. Okay.
So that I wanted to clarify, because it's not them taking 10 months actually producing the pier. It would be
That's fine.
from start. Yeah, okay, thank you.
Got it.
That's it?
Yes, couple things.
Oh, I missed
sorry,
Debbie.
sorry.
Debbie, sorry.
All I want to say is Happy Mother's Day to all the mothers out there.
Oh, I gotta get something for Vanessa.
That's Sunday?
It's Sunday, yes,
you
Scott.
came
in-
It is Sunday,
I know.
Scott.
I'm writing that down.
So,
Mother's Day.
yes, men, write that down, Sunday.
You could still make purchases on Amazon.
So, yeah, Happy Mother's Day.
Anything else, Debbie?
Sorry, go ahead.
I'm good.
good?
That's all I wanted.
A couple things. So regarding Trailhead, and maybe we want to put this on the agenda, we can discuss it. Mark, I know that I spoke to you regarding options to cleaning the skate park. A lot of graffiti, or what I like to call local arts on there.
Is there a lot?
Yeah, it's pretty bad. So,
You can just paint it.
so yes, that's what I was gonna bring out. So I wanna see what we can do in order to revitalize that. Just to put out there, just for everyone's consideration, I did reach out to SCG, who's doing Trailhead. They quoted $35,000 to repaint, seal, and beautify that area. So just gives you a rough number. That way, again, I'm not saying we should do it, but it gives you a rough number, as we get to it, so you can get quotes for.
Being a proponent of the skate park, and
Mm-hmm.
I don't know what the answer is, but can you reach out to like Tim Payne or other skate park manufacturers to find out that you put the right paint on there? Because you don't want to put something too slippery.
Right.
I can't.
Yeah, you don't
say-
want to seal it and then make it slippery. Yep, I get it.
Yeah, so,
Yep.
but you don't have to use Tim Payne, they're the ones that built it, but if you just have them reach out and find out what is a good
Base, yeah,
topic
yeah.
for it.
So yeah, if you could find out from that, Mark, and see what options we have to either, do we have to repaint it and beautify it, or can we just clean it with commercial high-pressure wash?
35,000?
35,000.
Okay.
So just putting out there for everybody. Second thing is, I did meet with a local resident today for lunch. Actually lives in my neighborhood. He is interested in starting almost call it a Minneola local business club or local business committee or whatnot, just a way for local businesses to come together that are registered in Minneola for networking, for events and things like that. Also could be a way to bring awareness to other restaurants, as those meetings can be in those restaurants around Minneola as well. So again, something for the council to consider. That way we can talk about, see if we want to make that an official committee or, like tailored to like the Parks and Rec. So it's not an official committee, but, or if we just want to sponsor it, let's just keep that in mind as we.
Would that be redundant to the Chamber of Commerce?
Yes, and I'm glad you brought that up. So while the chamber is countywide, this is nowhere near trying to compete with the chamber. I think the chamber does an amazing job. This is something that's local to Minneola, just to bring awareness to it.
If I may, you have the South Lake Chamber, which supports all of South Lake, and then you have the Main Street area, downtown Claremont, which is like a subset of the chamber. They work with the chamber, but it's just so specific because the residents or the businesses, and mainly if you think of what's going on in city center, their specific needs will be a little bit different, just like downtown Claremont's needs are a little bit different. So they just become a unified voice and usually become part of the chamber at some point in time.
Okay. All right, I guess it's just the thought process, but yeah, okay, sounds good. Other than that, that's it. That's all I got.
Joe, anything?
Nothing.
This is my last one, I guess, so make it short and sweet. The way I talked to Scott, I think next meeting, it will be, my resignation will be item 1 on the council discussion and action items. Item 2 will be appointment. On the appointment piece, does the public have to speak on that, or do they? So
Yes.
So they speak after each appointment? If appointment goes through, or they just get one and done, or how does that work?
Just once. You mean just for the filling the vacancy, that
Yes.
selection? No,
Like if they say, okay, we want Peter, and then everybody gets up and speaks, says, we don't like Peter, and then they say, okay, we want
Paul?
No,
but we're
I
gonna
think
choose Mary.
just one-time comments on the vacancy. It's just part of the public participation
So
statute.
basically, I just want to understand, so basically, when they go to that, then you do one-time comments, and then it comes back to make a motion, so they don't get to comment on the motion.
Correct, yeah, you don't have to, you can, but you don't have to allow
That's up to
comment on.
you,
on
who will
those.
have the gavel at that point in time.
Right.
Okay?
I would envision just one
And then the
public
third one will be the appointment of, the third item will be the appointment of a vice mayor. That's how we're doing it? Boom, boom, boom. Okay, and I will be submitting my letter of resignation to Scott. We just got to get the point of saying exactly when it will be, because we were trying to have a time, because you don't know if somebody gets caught in traffic or something, so it'll be like item 1.
Well, since it's your last one, thank you, Pat, for all your years of service here. You've left this city in a great place, so thank you.
So thank you very much. I appreciate it. I think it's, I listen to people here. A lot of people I don't agree, I have not agreed with in the past, but I do respect them. Hopefully they understand my vision, but I think, Jennifer, I've had our issues, but I understand where you're coming from. I don't think there's anybody here trying to burn down the city. even with everybody who's running, I think the city will be fine where we go. I think we have a great leadership with Mark and his team. I think everybody just does what, we don't always agree, but I think everybody's heart is in the right place. So I can comfortably leave knowing that whatever happens in November, that the city is not going to go to hell in a handbasket, whoever makes it on up here. And however it turns out, I think everybody who showed interest was phenomenal, and I feel comfortable. But I will be, when I step away, my wife and I had the discussion, I have to step away. I can't step away and, so I'll be reaching out to the admin of the Hills group, even though I do find it entertaining at times, knowing what dogs go to bathrooms and what neighbors. I will probably be getting removed from the groups that I'm in. I'll be getting removed from those groups just to exit from all of it. It'll be a good piece.
I
but-
mean, I will respect that. I don't agree with it, but on the other hand, I would really appreciate it if you could go to the chamber breakfast and at least be present at that event.
I'll be at the chamber breakfast.
Okay.
I'll be at the breakfast. Oh, which
The
reminds me.
Mineola Chamber Breakfast.
Yeah,
Not
the Mineola one?
the
Yeah,
Mineola one in
yeah.
July.
I will show
Okay,
I will show
thank
that
you.
one.
Okay.
We have an event, Lake 100 is next Wednesday.
Mm-hmm.
I am supposed to, I've spoke to them, I told them that they would have a representative from Minneola, will be on the panel, it's gonna be at Bella Colina.
They said they're not having a panel. They're saying it's a roundtable discussion. That was from Amelia Swart.
That's a panel.
No. Panel meaning like what they had last time at Lake 100, excuse me. No, exactly. Panel was when they had all 4 or 5 people that were up there and we did question answer. This time she said, no, it's just everyone at a round table and just talking and that's about it. So,
Well,
no, it's a different type of panel and Amelia had
When we
mentioned
did the
that.
one, because I did the one at, where were we at?
Up in Howie.
Up in Howie, it was.
Oh, I went to that one.
It was a panel,
Yeah.
and that was, so however it must be, there should be somebody there representing the city, speaking on behalf of the city of Mineola. I will defer to Pam if that is something that you would like to do, or anybody else would like to do it. I am fine with it, but I think it's time to start passing on the reins. So-
Sure, absolutely.
So do you,
I was going to go,
okay, do you want to speak? on-
and I will do whatever I need to do, and if I'm, for whatever reason, I'll get with Mark. Let's put it that way.
Can y'all just figure it out?
Yep, we'll figure it out.
I just know who it's not going to be.
Yes,
But I am going.
yes. Mm-hmm.
It's free food. So, okay, but thank y'all very much. With that said, can we get a motion for adjournment?
We have CRA. don't
Oh, motion for adjournment this.
Oh,
forget. Yep, so moved. No, wait, so moved. You need a second.
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 No, you need a second. All in favor?
All in favor?
Aye. You didn't? Okay.
Okay. CRA meeting. Call to order Mineola CRA.
Shoot, I forgot about the CRA.
Of the United States of America, and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
It's a little song, Joe.
Public comment. Bringing back. Nathan, can you please wait before you leave? Art. Yes, sir. Thank you. Council, city manager, consent agenda.
Looks good. Make a motion to approve.
Motion.
I'll second.
All in favor, say aye.
Aye.
Boat dock.
Do we have to read it, Scott?
No.
Make a motion to approve?
Second.
You can't second.
I need a second.
Oh.
I'll second.
All in favor, say aye.
Aye.
All opposed? Motion carries. Final public comment. I got nothing. It's been a wonderful time. Looking forward to see what the next generation does for Minneola. whoever that may be.
Make a motion to end?
Make a motion?
Second.
All in favor, say aye.
Aye.
Bye, everybody.
Bye, everybody. What happened, Joe?
To what?
Whatever you're doing. What were you picking up? A screw?
I had a piece of candy.
Oh, candy.
I'm standing over the bucket, this happened to me all the time. What's like curveballs?
It's gonna hurt the next
Thing
time.
there, but I can pick it up.
I got you, Joe.
Done.
I'll give it to
So
Mark.
done. No, it was not.
I have a question for you.
Yep. Hey, good night.
Good night. Pat, don't forget your keys are here.